The standing counsel for the respondent bank, his brother got hurt in his head, Lordship. He's completely paralyzed. Lordship. Yes.
What do you want?
I beg for an adjournment, Lordship.
For the petitioner?
For the respondent number 427. That is the bank, Lordship.
Matter pertains to?
Lordship, on the last date, we were given time for taking instruction from the bank regarding to a few questions, Lordship.
My lord, petitioner's bank account was sealed and his license was, my lord, cancelled with a stigma, my lord. The lordship.
Oh, yeah. I put those two queries.
Yes, ma'am. Yes, sir, Lordship.
What happened?
Lordship, his brother got hurt on his head. Now he's completely paralyzed. He is admitted in Bell City Hospital.
Who?
The standing counsel's brother, Lordship. Mr. H. Alia.
We accommodate this to be fixed on some other day. On account of the inconvenience of the counsel for the respondent number 427, the matter stands adjourned to be listed on 10th of August 2026.
Can you please come earlier, my lord?
On 27th of July 2026.
But I get to mention item number 2.
Yes.
In this case, we have filed an affidavit. On your platform.
Item number 2, what business you have?
We have to file
Content matter.
You are appearing for whom?
from the chief engineer, railway. I have to
What is there to file affidavit? I've asked you a particular question. Didn't it?
They have filed a affidavit giving me a copy also, giving us a copy.
Then
I've gone through that. They are saying that according to them, we are entitled to 30 lakhs. And that they are they want some.
if they are saying that, then that is the amount, then it is a subject matter of a future litigation. Anyways, you have filed the affidavit.
Yes.
Okay, what do you want now?
The lordship, bring it to the record, look. I have, or it's a dead.
For the senior advocate to mention this matter in the, where is senior counsel, you are mentioning this matter? Is it befitting for a senior counsel?
No,
Is that?
But they are very scared of.
Huh?
They are not very comfortable to, because it was not filed on the day before yesterday. They requested me to make it.
Okay. Let's call for that.
So with respect to item number 35, I have instruction that the petitioner no longer wishes to pursue the matter. Lordship. I have been instructed to withdraw the matter. Lordship. You will kindly allow me to withdraw.
Mr. Ali, the legal counsel appearing on behalf of the petitioner submits that his instructions to withdraw the listed petition. According the petition stands closed for withdrawal. Interim orders if any stand.
Okay.
May it please your lordship, I beg to mention item number 26. My senior counsel, 26.
Yes.
My senior counsel, Mr. Argusami Sons, has expired the day before yesterday. Kindly,
On account of the bereavement of Mr. R. Goswami, matter stands adjourned to be listed again on
kindly adjourn the matter after 3 weeks.
6.
Obliged lordship.
I am protection number 2. Lordship.
Is there any interim orders? No.
On behalf of others. May it please your lordship. I beg to mention item number 44, lordship, with the consent of the other side, lordship, the matter may be taken up any other day, lordship.
What?
Item number 44, lordship.
44, what do you want?
Lordship, matter may be taken up any other day because my senior is, lordship, unable to appear before this court due to his poor health condition, lordship.
Counsel appearing on behalf of the petitioner seeks for an accommodation. This matter on 14th of September 2027.
Yeah. My lord, in item number 42, we have filed affidavit in reply to that. It may be called for.
Sorry, Lordship, last time I missed. I can because of it, Lordship, that part of the order. Lordship, regarding the content petition, Lordship, the order has already been complied, Lordship. Petitioner has got 25 bighas of land, out of which Lordship, petitioner has got 25 bighas of land, out of which 11 bighas has been utilized by the APGCL, and for which compensation has already been given to them, Lordship. Remaining 14 bighas were not being utilized by any other, not by the them. And there is a speaking order also, we have filed our affidavit also.
So have you passed that order?
Lordship, already
An order has been personal, but an order has been personal. We have been served a copy of the affidavit today morning.
What does it say?
It only says, my lord, that out of the 25 bighas of land, 11 bighas have been utilized and the remaining 14 bighas have not been utilized. However, my lord, we do not have access to the remaining 14 bighas of land, my lord. That was our grievance, my lord.
Okay.
So this order is there,
Yes, this order.
whereby you are now permitted to fully utilize, use and for cultivation and other, the said land as land.
The difficulty is, my lord, we do not have any access to that land, my lord.
You will have this in view of this order. We do one thing. You are the Kardianglong or NC Hills?
NC Hills, Lordship.
This is the by the revenue secretary.
Lordship.
We asked the DC. The revenue secretary shall, the secretary revenue shall take due steps for thereby instruct the DC to hand over the possession and give an update on the next day. Pursuant to the order dated 19/6/2026, Mr. R.M. Das has appeared before this court on behalf of the learned, Mr. R.M. Das, the learned counsel has appeared before this court on behalf of the respondent number one and have placed an order and have referred to the annexure 3 to the affidavit filed by the respondent number one. From a perusal of the annexure 3 to the affidavit filed by the respondent number one, it is clear that the additional secretary revenue NC Hills Autonomous Council Haflong had categorically mentioned that the remaining 14 bighas of land which have not been utilized by the APDCL can be utilized by the petitioner. Numbers 2 and 3. And they have been permitted full right of use and cultivation over the said land as landholders. Mr. So-and-so, who appears on behalf of the petitioner, submits that though such an order has been passed on 25th of March 2025, the petitioner have not been granted the access to the said land. The respondent number one is hereby directed to take steps with the district administration to demarcate the 14 bighas of land and further see to it that the possession thereupon is handed over to the petitioners. The petitioners are also directed to cooperate with the district administration as well as the revenue authorities of NC Hills in that regard. An update to that effect be placed before this court on the next date. List accordingly on 17th of August 2026.
Much.
Yes, what has happened? Money?
Paid. Already might have deposited in his account.
Who is repairing? Where is Mr. R.C. Saikia?
The next page might not would find. Deposited in the account of Mr.
Let's wait for some time. Mr. Manath, can you ask somebody to call Mr. R.C. Saikia? Yes, what is this?
In this case, I am the legal aid counsel. Madam. Here we have challenged the import removal order of the petitioner, which is at page 49. He was removed from service. The basic allegation against him, the unauthorized absence from duty.
Where is the order?
My order is at page 14.
The
Page 49.
48,
49.
49. What is your case?
But my case is that he, since this time, my lord, for unavoidable circumstances, he could not attend the.
Why haven't you filed an appeal?
My lord, actually, what this is a legal aid matter, my lord.
So what?
But,
Does it change the character of the
No,
proceedings? Then
but I could not contact with the client.
you should have advised the legal aid people should be advising. He should file an appeal instead of coming out here. We'll consider later on. We'll do one thing. Appeal filing is 30 days, no?
But again, but there is an the Assam Chief Judicial Minister establishment rules, my lord. As per that rule,
You go as per the Assam discipline and appeal.
Assam Judicial.
It's 30 days. We condone the delay and ask you to file the appeal within 30 days. Because we cannot allow you to, there's an appellate remedy. This is 15, 15, 158. Heard Mr. So-and-so, the learned counsel appearing on behalf of the.
As a legal aid counsel.
So what? Your name is glaringly appearing out there as a legal aid counsel, so what? Are you not a counsel?
Yes, sir.
Then. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner as a legal aid counsel. And Mr. G. Busher, the learned senior counsel, as well as the standing counsel of the Gauhati High Court, representing the respondent number 2 and 3. Mr. J.K. Goswami appears on behalf of the respondent number one. The present petition has been filed challenging the order dated 16/12/2025, whereby the petitioner has been dismissed from service
Yes.
on account
No
of
problem.
unauthorized absence. It is relevant to take note of that the petitioner having been imposed with a penalty in terms of sections Rule 7 of the Assam Service Discipline and Appeal Rules 1964 has an appellate remedy under Rule 15 of the said rules of 1964. This will be under 15A and under 15 capital A. Under such circumstances, as the petitioner has an appellate remedy, it is the opinion of this court that the petitioner ought to first exhaust the statutory remedy and thereupon, if so dissatisfied, can approach this court. This court also takes note of that the petitioner, on account of legal advice, had approached this court by filing the present petition instead of approaching the statutory authority, appellate authority. Accordingly, this court condones the delay in preferring the appeal under Rule 15A of the Assam Discipline and Civic Service and Appeal Rules, Assam Service Discipline 1964. And it is further directed that if the appeal is filed by the petitioner within a period of 30 days from today, 15 days, because it is 15 days, 15 days from today, the appellate authority shall consider the appeal on merits without insisting on the question of limitation. All right.
It may be 20 days now.
I cannot. The rule says 15.
Paragraph 4 there. Paragraph 4.
Where's the affidavit? Where's the come?
We have an extra copy.
I thought it was
Paragraph 4. Then we
So they say the amount is 28 lakhs.
20.
Okay. Let's have it after 3 weeks. In the meantime, you clear this amount. You may very well file another proceeding if you have entitled for anything else. That's
More
the
than 10,
difference.
more than 10.
Pursuant to the order dated 19/6/2026, passed by this court, an affidavit has been filed by one Sri Subhanand Chanda, who is serving as the Chief Engineer Public Construction, there's 7 Manipur project. In the said affidavit so filed, it is categorically mentioned at paragraph number 4 that the bill number 29 capital A had been considered and submitted to the accounts office for checking and arranging the payment. It is also mentioned that the account office has also vetted the bill after due internal check as per the illustration given by the spot by the orders dated 26/6/2023 and 19/6/2026, and vetted the bill 29 capital A for an amount of rupees 28,91,803, and the payment would be made within 3 weeks. Considering the said statement so made in the said affidavit, comma, this court fixes this matter on 19th of, on 3 weeks.
After first week of August. If
On 10th of August 2026 for an update as to whether the payment of rupees so and so have been made to the petitioner in the meantime. What is this IA? Item number 3. What is this? Who has come? Three. Okay, none appears on behalf of the petitioner. On behalf of the applicant. When the matter is called, accordingly matter stand adjourned to be listed on 18th of September 2026.
we are not directed to file the affidavit, my lord. Lordship, allow me some time because in the meantime, the records were misplaced, my lord. Very, so what the records, my lord? I received my instruction. My lord.
Yeah, what is this matter about?
This is in regards to a demolition of a shutter from the ground floor of a property to the 3rd floor. So there was a complaint registered by saying that this is obstructing the staircase and that it is going to create a problem for security reasons. So initially a notice was sent to us. They said we will either demolish or perhaps seal it. We replied by saying that this is only a shutter, which is temporary. We keep it open most of the day because it's also used by our workers, which is that Vishal Mega Mart shop. So subsequently, we filed a reply by saying if we will remove it. But then there was an order passed for sealing that particular part of the wall. That was done. Subsequently, on 9/11, they got in and broken everything off. So we came to the court saying that at least you should have been given a notice before breaking it, because we agreed it was seen on that particular day by an order passed by them.
So they've broken the.
They'd broken it, and we've been operating like this without that party still remains vacant because we can't do anything. Because there was an initially suit filed by us where between the dispute between the tenant and the owner, where there was some status quo order passed, so we couldn't do anything on it. So that matter is still pending, I believe, in the trial court, and there's some dispute still going on between the landlord and the tenant. We are a tenant.
Who has broken it?
I'm sorry, GM.
Have broken the shutter.
Yes, that shutter along with little bit of concrete stuff also, because they said that
So
this was.
you have a claim for damages, go there before the civil court. Okay.
This is an emergency exit, madam.
It's,
This is an emergency exit. They are using it, basically using it a commercial purpose. They are storing the
Okay, why should we decide
Yes.
on this thing? Go there before the civil court.
compensation for their fuel.
No point here.
I have only on.
It has
the ground.
already been broken up. It's
Yes,
already been demolished. So if it is demolished out there, what remains out here?
They
Means
didn't give
should
us
we
the ticket,
direct
madam,
the
nothing.
GMC to again put the shutter?
Without even intimating us, no notice.
It's
nothing, they
okay.
went ahead
It's okay. Now that position is, if without intimation, any notice or any order has been passed, then obviously we could have done something. As of now, it has already been demolished.
Yes.
Now, the question is, if you want a decision from this court as to whether you can put that shutter, I can look into it.
Yes,
You want that?
that is the only thing I had come for. So I believe because that was
Did you take the permission for the shutter?
it was originally not in the plan, but because we were tenant, my lord, we did intimate, but there was always a dispute between them.
No. My question is, did you have the permission to put the shutter?
My lord, I'll have to verify.
No, that is the question. That is the only thing. If you
Because-
want that,
Yes,
if you want that order, that is the only case.
okay. In terms of the agreement that was executed, my lord.
No, not the agreement.
That was.
The shutter, if you are putting a shutter out
Yes,
there,
subsequently it was done.
whether it had the permission of the GMC, because the GMC bylaws requires this shutter to
Yes.
have these permissions. Do you have that? So better off go to the civil court than to get an order out here.
Have to verify.
If you have any problem with the damages out there, means they have carried out all these damages and thereby caused, and you had the permission or you could have erected. These are questions of facts which can be decided by a civil court. Ask for compensation.
So the first query, my lord, I'll have to clarify because I'm not sure whether that shutter was
If
built initially. I'm
You
not
do,
sure.
if you are not aware, your entire case hinges on that aspect.
Have to take that. Sure.
No, the entire case hinges on that.
Yes,
And if that is, you see, you have come before this court that they have demolished it without a notice.
yes, my lord.
That's your case.
No, madam, that is not the case, madam.
That is not the case. Case is that the structure that was built was blocking the entrance and exit, which they are saying that had created a security reasons and it was a fire gate. So the existence of that shutter was a problem. So in terms of that, they gave us a notice by saying that this has been unauthorizedly put. We replied by saying it is not unauthorized, it has only been built later for a security purposes. So he said, we keep it open most of the time on the day because people are also using it as a way to it. Subsequently, they gave a notice by saying, no, we'll have to seal it because this is an unauthorized construction. That is what they are saying. In terms
Now
of
they have demolished it.
they have demolished.
So therefore, there is no existence of the shutter.
No, there's no existence.
So if there is no existence of the shutter, this court can only hold that the existence of the shutter was necessary and you had the permission to put that.
Right.
That is the only thing this court could have held it. This court otherwise cannot now direct the GMC to put down the shutter. Or I can't get you a permission for putting the shutter. It has to be as per the
And
bylaws.
their process was, the 1 and 2 notice was replied. Thereafter, 2003, it was found that the shutter is legal there, so it was demolished. Process was totally followed.
You are a tenant.
I'm telling.
But do you have a right to put the shutter?
That was a permission. In fact, that was a dispute initially
It
arose.
is between those persons. If the owner
Yes. And
does
the
not have the permission to have put the shutter, you also being
tenant.
deriving the right from the owner, you also don't have. And where is that in the lease agreement that you can put the shutter?
Uh, lease agreement, my lord, that is.
Page 64 and what? No, 46.
46. Sorry, 46 is the lease agreement, my lord.
Where is it that you have the permission?
Uh,
You don't have the permission.
it's not.
Yeah, arbitration clause also they are in place. Page
Everything
51.
is okay.
There is-
That is between him and him.
Him.
But where is the permission for you to construct? I think better dismiss it.
Why?
Finish it. Why go trouble the civil court? Huh?
No, no,
Dismiss. Full and final.
let them go to the civil court, my lord.
No. Why should I?
Lord, I leave it to us.
I leave that to your lordship, but the suit is anyway pending in the trial court.
That's a different aspect.
Yes. In
Now,
that
if you
respect, my lord, in
have,
regards
that,
to
there is a
suit-
suit between you and the landlord. That's a different aspect of the matter. I'm not on that because the landlord has nothing to do out here. Here is the action of the GMC.
James,
Now, if you had no permission to erect the area, or even the lessor did not grant you the permission, mere erecting, you have no right.
just give me a day's time to come back to your lordship, whether that permission was sought by us. Just give me a day's time.
No, first of
to come
all,
back on Friday.
you were not permitted even by the lessor.
That
As
is
per the
something,
agreement.
that is something, my lord, I'm not very sure. Your lordship.
It is
Just give me
apparent
some-
from the agreement.
Was subsequently built. That is what was told to me. So I don't know whether there was permission was sought. That I'm not very sure. That
Okay.
is just until Friday, my lord, I'll just seek that clarification. The lordships can then pass an order.
In page now 47, CL number 4, my lord. Repair and maintenance is given.
But that is repair.
Right. Only
Should be
repair and
repair and
maintenance is
maintenance. I'm not
Page
sure if
47.
permission was taken for.
CL number 4. I don't know.
No, it will be borne by the lessor.
Yes, sir.
Yes, sir.
Understand. That part is there.
How Mr. Abi Tukandal and his senior counsel is assisted by so and so appearing on behalf of the petitioner. Mr. Asbora appears on behalf of the GMC authority. You are appearing for somebody?
Right.
So and so appears for the respondent numbers 5 to 26. Performer respondent numbers 5 to 26. Taking into account the office note, the service is due to be complete. The question arises in the instant proceedings is as to whether the official respondents were justified in demolishing of a shutter constructed by the petitioner, who admittedly is a tenant of the building, wherein not only the petitioner, the private respondents numbers 5 to 29 are also tenants,
Owners,
are also owners.
they are the owners.
5 to 29 are the owners. As per you, permission was granted or not? This court have also perused the lease deed, on the basis of which the petitioner entered into possession of the suit property, of the property of the demised premises dated 1st of June 2018. And from a bare perusal of the said lease deed, there is nothing mentioned, thereby permitting the petitioner to construct a shutter. In addition to that, it is the submission of the learned counsel appearing on behalf of the performer respondent numbers 5 to 29, that there was no permission granted to the petitioner for construction of a shutter. First, it is the opinion of this court, it is the prima facie opinion of this court that the dispute in question is purely a civil dispute. Be that as it may, Mr. R.B. Kukan, the learned senior counsel appearing on behalf of the petitioner, seeks for an accommodation so that he can obtain instructions through his instructing counsel as to whether the petitioner had at any point of time been granted the right to raise the construction of the shutter. Right, to construct the shutter in question. Accordingly, list this matter again on 24th of July 2026 for an update. For admission. What is this, Mr. R. Lee?
Lord, as per office note, my lord, service is added and we have checked in the website, my lord, the incumbent has been transferred, my lord. Direction, my lord, is 15, my lord.
What is the case?
Case, my lord, regarding, my lord, the settlement of land, my lord.
Huh?
Land, my lord, settlement of land, we are pausing land, my lord. My father was paused, my lord, and his name was recorded in the record, my lord, in 65, my lord. And out of 30 bigas, my lord, 20 bigas has been converted from, my lord, government to Miyadi Bhatta in the name of, my lord, a government teacher.
In the name of
A government teacher, a school teacher,
government teacher.
lordship, school teacher, my lord, in a government school. And he also tried to dispose us, my lord, from our possession. We filed petition, my lord, and we also filed application under Bosundara, my lord. It was not accepted. Then we filed application before the deputy commissioner, my lord, for taking necessary action. No action was taken, therefore we approached the court. And this now court, my lord, page 15, paragraph 9, order has been passed.
Read the order.
Paragraph 9, my lord.
Ah.
Considering that there was serious dispute with regards to the question of fact, this court is of the view that the matter should be decided by the deputy commissioner of the concerned district, namely so-and-so, into inter-se claim made by the petitioner and respondent number 5 in respect of the land in question. The deputy commissioner will call for a field verification report supported by necessary records as available in the revenue office and also give opportunity of hearing to both the petitioner and respondent of 5. And thereafter pass a detailed order deciding the dispute between the petitioner and respondent of 5 as to the inter-se claim of petitioner and respondent of 5 in respect of land measuring 10 biga 2 kata 1 lesser covered by so-and-so at village so-and-so, the circle of it so-and-so. This exercise will be carried out by the deputy commissioner.
Now, what is your thing?
Well,
The deputy commissioner with reference to the IML, therefore you are asked to appear at 3 p.m. Then what happened?
nothing, my lord. Thereafter, no conclusion, my lord.
No?
Yep.
Did you appear
Lordship,
on the date of hearing?
lordship,
Did he appear?
private respondent.
Huh?
No, my lord.
How do you know? You
Well,
written in your petition. They are looking into it.
So, my lord,
First of all, you have, this court have asked that a purely civil dispute to be decided by the deputy commissioner.
my lord, government land, therefore, my lord, not a civil dispute, my lord, because we filed, my lord, for settlement. Allotment. We have also applied for.
Mr. Aradi,
Lord.
don't make that submission before me. No, that type of
And-
submission is absolutely courageous.
In paragraph,
It's
my
a
lord,
purely civil matter between you and the respondent number 5. As to who is in possession of the land. Who has a right over the land.
right, my lord, regarding right, my lord, the government file affidavit saying that is a government land, so they cannot, my lord, allot.
government land, no government land, whatever land. A person has a right to remain as a possession for another person. What is it? You cannot be thrown out by another trespasser. That's the law. But you cannot obtain an injunction against what? The owner. Owner is the government. Your fight is between you and the respondent number 5. So why is the deputy commissioner deciding all these things? How can the deputy commissioner decide the question of possession and all these things and then pass a detail order as if it has been given the status of a civil court? Now you have made the who is the person?
Deputy,
Why have you filed this? You obtain instructions as to what has happened in this one. Very difficult. The present application has been filed alleging willful and deliberate violation to the order dated 21/11/2024 passed in WPC number 5176 of 2023, whereby there was a direction issued upon the Deputy Commissioner, South Salmara Mankasa, to decide the interstate dispute between the petitioner and the respondent number 5 in the petitioners and the respondent number 5 in the said writ petition. It is the specific case of the petitioner that though the period of 60 days has elapsed, 60 days now, from the date of receipt of the certified copy of the order, but till date, there has been no decision so passed by the Deputy Commissioner, South Salmara Mankasa. Taking into account this court have requested Mr. J. Handig, the learned junior government advocate, to obtain instructions from the Deputy Commissioner, South Salmara Mankasa, as to whether the order dated 21/11/2024 passed in WPC number 5176 of 2023 have been complied with or not, and if so, the reason therefore. A copy of the petition be served upon Mr. J. Hendick during the course of the day by the learned counsel appearing on behalf of the petitioner, so that he is in a position to obtain the necessary instructions. To list this matter again on 19th of August 2026 for an update. The registry shall show the name of Mr. J. Hendick, the learned junior government advocate, as account and in the context.
okay.
Ready.
But this is regarding non-issuing the sale permission to the petitioners. Now the order lordship will find at page 14. Property part at page 18, para 11 and 12.
This is the same order that day,
Yes.
some order.
Other
passed.
day. Yes.
Same type, huh?
That has
Same
been
type
fixed on
order we passed that day. What was the
7th
name?
5th of
number the
April.
case?
5th of August, madam.
Whatever, 278, I think. One time petition.
I think we had it on Monday.
No, one not see it was fixed on August 17.
No, we had it on Monday.
Lordship.
Yes, what is your number of your case? You were the person.
279, I think. Yes. Two seven nine 2025.
279, nah?
Sunil Das.
79
Sushil
of 2025,
25
same order passed.
of 5th August.
5th August. Huh?
5th August.
5th August, same.
Developers.
We give a copy, huh?
I
Order complied. Mr. Ida, the learned counsel appearing on behalf of the petitioner submits that the order dated 29/11/2024, passing WPC number 5798 of 2024 have been duly complied with. Mr. Ali appears on, Ali appears on behalf of the respondent, sole respondent. Accordingly, the contempt proceedings stands dropped. What is this? Contempt for what?
Contempt for Lordship, Honorable Court has passed the status quo order, but Lordship, despite this order, the respondents are demolishes the house of the petitioner and Lordship,
What? Who is demolished?
Lordship respondent number 3, Lordship, contemptor number 3.
Huh?
Contemptor number 3, Lordship.
Who is contemptor number 3?
Private respondent, Lordship. Manikali, Lordship.
What has happened after 6 weeks? What has happened to the resolution?
The writ petition is still pending, Lordship.
Okay, list this matter on 5th of August 2026 along with WPC number
WPC number 513825, Lordship.
5138 of 2025. Meet of 2025. See on that date. And be ready with your petition. Purely civil dispute. You have heard? Who are you?
That is the CDC and circle officer.
You have no business. You have unnecessarily made these people a party. Yes, Mr. Counsel. Why have you made these people a party?
In fact, man, the FIR also is not against us. It's against some unknown person.
Why have you made these people a party? We'll see on the next day.
Yes.
Get your
Sanur Ali.
Get your client instructions from a client also to at least have in his pocket 1 lakh rupees as cost. Okay, for impleading these people unnecessarily. Your allegation is against the respondent number 6 in the writ petition, who is the respondent number 3 in the contempt petition. Yes, Manik Ali or something.
FIR also against.
Then why are you making these people a party? The circle officer and all. This direction of a passing of a status quo order was qua those respondent number 6. Why are you making these people a party? We impose, ask your client to obtain, get from your client, try to
Yes,
get
Lordship.
a demand draft of 1 lakh.
Petitioner was possessing the land last 30
Forget about that.
30 years.
Why? That the dispute is between you and the respondent number 6.
No, Lordship, and government respondent also, Lordship. Government respondent also. Lordship, petitioner was possessing the said land for last 30 years, Lordship. And Lordship, petitioner was paid to the Bedokhali Zoribana also, Lordship. And after that, Lordship, petitioner was applied for the Bosundura 1 and 3 also, Lordship. During the pendency of the Bosundura 3, Lordship, in the private respondent, Lordship, the mutation was done in favor of the private respondent. But private respondent never, Lordship, applied for the Bosundura, Lordship. And he is not possession the said lands also, Lordship.
So after the status quo order that was done,
After,
are you saying that after the status quo order that was done, is it your allegation in your contempt petition?
after the status quo order, Lordship, we have submitted the order before the Lordship respondent number.
I'm asking you, after the status quo order, did they change the name?
Money clear.
The respondent number 6 Enter into possession.
Till lordship, till the,
I will find you. I think we have a good case for dismissal. Okay. I think we do that. What is your allegation? Let's see.
showing late petition lordship.
Who is the person out there, page 38? Annexure 3B.
This is LRA, my lord, Grand Revenue of Stuffs
Ah,
in front of the Malik Ali house.
ah.
And my lord, page 41, my lord.
Ah.
It says, my lord, the dark number 334, name of the patadar Malik Ali, Father Rahim Ali box.
Ah.
My lord, and this is Malik Ali in front of Geotech photographs. Lordship 44. My lord, page 47, the report, my lord. The Malik Ali has filed an application before the circle officer. It says, my lord, can I read?
Ah.
With due respect,
Where?
page 47, my lord.
Page 40?
7.
Ah.
It's a translated copy, my lord, to the circle officer. Application of illegal possession of the patta land. With due respect, I beg to say on 8825, the government had allotted me a patta land in Chirakoti village covered by Doug number 328 instead of number 1 Chirakoti village patta land covered by Doug number 238. And my land is converted to government for the APDCL work. Thereafter, on 10/8/25, I started to live in the new allotted land with my family by constructing a house. But on the last night, Sudhir Paul with some goon tried to occupy my patta land and threaten my family. Sudhir Paul also tried to construct a house in my patta land, and after gathering of villagers, he played away by breaking the house. This is, my lord, on 8/8/2025, before passing of the status quo order. After
Why do you,
pass,
how do you say it be 88?
my lord, it said, with due respect, with the on 8/8/2025, my lord, page 47, my lord.
But this was given on 9/9/2025,
Yes, my lord.
after the passing of the interim order.
No,
Kindly see page 48.
yes, ma'am. Yes, yes.
Isn't it?
Yes, ma'am.
Then
It also says, my lord, if your lordship comes to page 22,
page
page 22.
of the petition.
No, my lord, the affidavit filed by us.
There's no page 22. His affidavit, his petitions ends at page
20, my lord. The 16.
22. 22 is whose petition? Yes, 22. Yes.
It is submitted by the writ petitioner. It said, madam, due respect, I beg to say, I am in a position of the below mentioned.
No, no,
civil-
page,
Page 20,
petitional affidavit.
22, my lord. Affidavit filed by the CDC, my lord. Code
By
district- Code district commissioner, my lord. Pretty Lekha Deka. Dr.
Huh?
Dr. Pretty Lekha Deka. Respondent number 1, man. Content number 1.
Page 22 is different. First of all, you don't get your papers rightly done. Here there is a different page number, you have a different page number. And we have only one affidavit filed by the respondent number 2. There's no other affidavit.
Yes, my lord. We file on, my lord. 6/12/25, my lord.
There's no affidavit. We have only one affidavit filed by one Shashi Bhushan Rajput.
That is a circle officer.
Where is the other affidavit?
Other, is there might be file on 6/12/25.
Show me a copy of it. And kindly get your page numbers properly done. Otherwise, don't appear.
Page 22.
What does it say?
Is Meredith, my lord.
This is not page 20, it is not yet come. But this spoke into a civil court. It has been stated by Mr. N. Das. The learned counsel appearing on behalf of the respondent number 1 and 2, that the respondent number 1 has filed an affidavit in opposition, which is however not on record. List this matter again on 22nd of July 2026, along with the affidavit in opposition filed by the respondent number 1. The registry is further directed to place before this court. Also tag the petition being WPC number 5138 of the 2025 with the present contempt proceedings. You go and find it out. Yes, yes.
Obliged.
Yes, item 11. Why are you filing a 227 petition here? So 10 is there. What is this?
This is regarding, regarding payment of compensation to be made in the wrong person. That's why this petition is filed by.
Huh? Is there a contempt writ petition?
Yes, my lord, distribution. The payment is going to made to the wrong person. That's why, my lord, I have filed this petition. Well, I have filed.
Complaint against the payment in favor of the client for acquisition of the schedule mentioned land for construction of road and the commissioner. Then what happened?
In the last occasion, my lord, instruction was issued to the respondent, my lord, regarding deputy commissioner, what process they are taking, my lord. This instruction is only required, my lord.
Now you refer it. Make a reference of that. This acquisition is done under what provision? Assam Mala. So Assam Mala could not have been done without an agreement. Agreement was with whom?
My lord, agreement with the respondent, my lord, but I am the owner, my lord. That is my case.
But anyways, you are acquiring it. Maybe Assam Mala.
Already acquired, my lord. I am the respondent number 7 and 8, my lord. We filed objection, my lord, and we also filed our written statement before the deputy commissioner.
Then
My lord, this is pending, my lord, for disposal.
now can the deputy commissioner decide this? This is another big problem which is going to.
Already registered a miscase. my lord.
How are you dealing with this Assam Mala project? Are you making this as regards the entitlement and apportionment? Because the entire agreement will otherwise fail. If he is not the owner, the agreement will fail.
His allegation is that I am not owner, my lord.
That's true. Can the revenue authority decide who is the owner? Yes. Absolutely. So therefore, how are you dealing with that issue? Very well, you have not made to the school. But how are you dealing with that issue? Assam Mala means that there is an agreement with a particular price. Now, if this agreement is entered into with a particular price with a person who is not the owner in respect to a land, the entire agreement falls. Now, can the deputy commissioner decide that? So it has to be decided by somebody else. So who is going to decide? So your entire acquisition has become bad. You have to go for this. The moment there is an objection out there, either there might be a case, the moment there is an objection by a third party, the Assam Mala fails, then you have to go under the Assam Land Acquisition and Acquisition Act. So the entire acquisition becomes bad. Because the deputy commissioner cannot decide this issue. A very important aspect. Don't do anything. Don't pay anything. We need to consider this aspect. Because this will have far-reaching consequences. Okay. You are repairing? Yes, sir. The government filed affidavit. You file your affidavit business. The issue involved in the instant proceedings, involves an important question as to who has the authority to decide the entitlement and or apportionment of the amount when the government have taken steps for acquisition of land on the basis of the Assam Mala project. It may not be out of place to mention
that when acquisition is mentioned, acquisition is done in terms of the Assam Mala project. It is based upon a agreement. And the question therefore arises as to whether the said agreement would hold good for acquiring the land if the person concerned with whom the agreement has been entered into has no right, title, and interest over the land in question. Neither the Assam Land Requisition and Acquisition Act 1964 nor the Assam Land right, no, the right to fair compensation law empowers the Deputy Commissioner or the collector to decide the issue pertaining to entitlement as well as apportionment of the amount when there is a dispute. Under such circumstances, it is therefore the opinion of this court that an affidavit clarifying the said aspect be placed before this court by the Revenue Department of the Government of Assam, inasmuch as it is under the Revenue Department of the Government of Assam that the scheme of Assam Mala project have been inasmuch as the Assam Mala project is a scheme for acquisition under the aegis of the Revenue Department of the Government of Assam. List this matter, Ms. So-and-so, who appears on behalf of the Revenue Department of the Government of Assam, submits that the affidavit would be filed within 3 weeks. List this matter on 3rd of August, 21st of August 2026. The affidavit be filed on or before 18th of August 2026 by the Commissioner, by the what? Additional Chief Secretary. Additional by an office, by a competent officer of the Revenue Department of a rank not less than the Additional Chief Secretary to the Government of Assam, Revenue and Disaster Management Department. It is further directed that taking into account the issue involved, the Deputy Commissioner, the District Commissioner, which one? Hailakandi, shall not release any amount to either the petitioner or the respondent number 6 and 7. 7 and 8. In respect to the acquisition of the land in question. 21st. Most of you informed it. And why are you here? Who is he? This land is done by whom? But is it under the NHI Act? How can the NHI do? Assam Mala be done by the NHI? How is it possible? They cannot. You have been unnecessarily dragged. Assam Mala is not with National Highway. Bharat Mala is different. You have nothing to do. Bharat Mala is. Service not complete.
Service is complete, Your Honor, as per office note 24.
Complete. Okay, what is your case now?
My case is that we are challenging the order of the State Commission. In an appeal, we are praying for setting aside the order of the appeal.
Taking
That-
into
that-
account that the
that-
repetition, that the instant proceedings is the proceedings under Article 2 to 7 of the Constitution, comma, the registry is directed to take steps for registering the instant proceedings under as a civil revision petition. Bracket IO. Rather than a writ petition and list the matter before the appropriate court.
The matter pertains to non-compliance of the order dated 13/3/2025 passing WPC 4507.
Line,
Non-compliance of the order dated 13/3.
has it been complied or not?
Lordship, here we have received an instruction which is incomplete. Lordship, and kindly grant us 1 week time to for further instruction.
How much time?
1 week time, Lordship.
1 week.
Lordship.
Mr. So-and-so who appears on behalf of the respondent number
Respondent number 1.
1
Lordship.
submits that the affidavit on behalf of the respondent number 1 would be filed within a week's time. To list this matter again on 12th of August 2026. In the meantime, the respondent number 1 shall bring on record its stand by filing the affidavit on or before 6th of August 2026.
Thank you.
What is this?
The petitioner
Application for restoration of the aforesaid case which was withdrawn with liberty on remand. How is it possible?
It's not material. Page 10 is the order. The
What is the matter about?
but the land matter, wherever the petrol pump is being.
Yes, what is this type of application?
Well, this application, because my lord, honorable court suggested me to file, yes, because it is a patta land, my lord. It is a patta land, but social forest, my lord, they have, my lord, evicted me, my lord. Because dispute between.
What? Evicted?
Yes, my lord, eviction has been already done. In spite of patta land.
Who?
A forest department.
This Bharat Petroleum.
Yes, my lord. Bharat Petroleum was established there, my lord, as it was a patta land. Subsequently, they have evicted some portion of the construction there, my lord, of the petrol pump. Subsequently, my lord, honorable court observed that, my lord, better you file civil suit because of the recovery of the say 86 lakhs already invested there, my lord, by the petitioners. So, my lord, I initially, my lord, as honorable court suggested me, my lord, my lord, I have given consent to close the matter with liberty to file civil suit there, my lord. But subsequently, the forest department and BPCL threatened us as you have withdrawn the case from the honorable high court. So we can again, my lord, leave this investment. What has been there?
What?
What has been already established there, my lord, by the BPCL company, that we will take back the say machines, my lord.
He's not a holder. Somebody else. He's the owner of the land.
Honor of the land, but I have given to the, my lord, land to the another person, my lord. It was by agreement. All deputy commissioner has given 3 times NOC.
Then
So in spite of that, my lord, forest department evicted. Already there,
Forest
your lordship,
Department?
forest department, my lord. All lordship order is there, my lord. Initially, it was listed before your lordship, my lord.
Case of eviction hearing is the land in respect to which the interim notice has been issued, is the land belonging to the commissioner wherein the petitioner has been issued a paper by the district administrator. Like counsel for the petitioner, therefore suppose that I have no jurisdiction with the statement, and as such, they cannot be
cannot be any eviction carried out. On the other hand, people who are appearing on behalf of students. The case the stand of the refinery is based upon the report being submitted by the additional deputy commissioner when he is taking the consultant only the notification, but has not taken into consideration the final notification within the land on which the petition is presently for within the reserve forest. So therefore, submit the petition of granting even an enforcement to the respective permissions of the submissions from
If the revenue file the petition. What did the revenue say?
Page 74.
Why are you making the Bharat Petroleum a party?
They have installed, they have given NOC and thereafter installed the project.
Unnecessary, your issue is against the forest.
Yes, madam.
Why you unnecessarily making the issue
Followed
with the
by
Bharat
the
Petroleum?
agreement, my lord, already tenant has established their
And
petrol.
first of all, this is and Mr. Das, are you not aware that this is not a restoration
Yes,
application?
yes.
What application should it be?
Review.
It has to be either review or a recall.
To recall, madam, my
It's
price.
a case of a recall.
Yes, madam.
Why you are filing a restoration application?
To recall the order, madam. I had- What? Yes, madam.
An application for restoration of the aforesaid case which was withdrawn with liberty.
Yes, madam.
Then it has to be a recall. There has to be a recall
A
application.
recall application, madam.
An application and the recall for the, because it was done on without the consent. You have to
Yes.
make it in that manner.
Yes, madam. I'll do that, madam.
It's not done. And
Yes.
it's unnecessary dragging these people. Have you been evicted?
Already evicted, my lord. Some portion of their establishment are there in the petrol pump of the my lord, tenant of the petitioner, my lord. That is
It's
why, my
okay,
lord,
you have been evicted.
evicted
By?
by the forest department.
So the forest department has already evicted.
Already.
Now you say that it is your land.
Yes, my
It
lord.
is a patta land.
Patalan, my lord.
So you want restoration of possession.
Yes, my lord. No,
Mhm.
I want, my lord, because my lord, restoration of possession and to recall this order and to keep pending the earlier requisition. Only that much.
No, that has no meaning now.
Because
You see, once you have been evicted, what it
Evicted.
means?
because my lord, other pair are also dear, my lord,
What other prayers are they?
to pay the compensation, etc. And my lord, subsequently their decision to evict the petitioner.
Now, have you
also-
been evicted when the petition was filed?
After filing the petition, they have, my lord, earlier
No.
also 4/9/2024, they have, my lord, order, and we filed, my lord, 11/9/24,
You filed on 11/9. You were evicted on when?
4/9/24.
So then there was a direction of maintaining shall not waive the petitioner shall not carry out any kind of construction of a building. You also shall maintain against the petitioner on the basis of the interim notice. So as on that day, when you got the order,
Yes,
you were already evicted.
evicted. That is
So why this was not being
my
informed?
friend,
Because my order which I passed, was based upon an assumption that you have not been evicted.
evicted, my lord.
Then
But subsequently they have evicted, my lord.
you were evicted prior to that. You were evicted on 4/9/2024.
4/9/24.
Whereas you came before this court on the basis of a notice of 27/8.
Yes, my lord. Because earlier requisition was,
The remand to provide him the NOC from the State Department having installed the retail at the Pasta land, so and so. which is non-prior and also ban for paying for educated because the wrong eviction operation made by alia and or PS2.
Page
Page to direct the officials not to evict that area of your petitioner to dismantle the entire project of the establishment, so and so, so and so, so and so. Now you have all, now you have been, you are asking for stay of the operation of the interim notice.
Yes, earlier, the tenant filed the petition. It was withdrawn because landowner has to file the case, madam. I have stated in paragraph 26, page 9.
All understood, Mr. Counsel. My question is, on 20, you asked for stay of an notice of 27A.
27, madam.
On the other hand, you have been evicted.
Yes, evicted.
Then
Because the case earlier case was filed on 5/9/24 and case was withdrawn 9/9/24, madam.
you can't have the petition.
That's it.
Civil suit. You do one thing,
Status
Oh.
quo, madam.
that's the only way civil suit.
Yes, madam. Giving that
It
status
is
quo.
already given to you.
No, status quo has not given.
How can there be a status quo be given when you are withdrawing the petition?
Yes, my lord. Honorable observed, my lord. That is why I have given consent, my lord. But order is also, my lord, appears to be, my lord, that because if I cannot satisfy the order of this, my lord, civil court, my lord, I can avail the remedy again before the honor.
You have been already evicted.
That's it.
You have been already evicted.
Already evicted, my lord.
So
In spite of
once you
that,
have
my
been
lord,
already evicted, now the question is for recovery of possession.
recovery of position.
One is recovery of possession. Secondly, you have to show that it is a patta land
Patalan, my lord.
and it has nothing to do. This is a question of who?
Yes. Well, already, my lord, amount has been already invested there, my lord.
You have not invested. Invested is by the tenant.
Tenant, my lord.
It
But
has been invested
You
by
have an
Bharat
agreement
Petroleum.
also, my lord. Earlier case was filed by the tenant, my lord. But subsequently, my lord, we have filed this.
Obviously. So therefore, now why should we allow this petition? We should reject it. You have to go before the civil court.
But so far, the rest of the, my lord, they have projected to again evict the petitioners, then, my lord, the other construction of the, from their part, my lord. Other construction establishment of the petrol pump. They have already taken away the bank, my lord, the equipment.
So they have nothing. What are you going to do with the tank? The tank also doesn't belong to you.
No, my lord, already, my lord,
Bharat Petroleum may very well come over and say that look here, my tank is there, allow me to take over.
But 28 out of my lord, 21 lakhs, my lord, there. 18 lakhs, my lord, already there, my lord, it is refundable. But 3 lakhs, my lord, all 3,20,000 invested there, it is not refundable from the BPCL, my lord. That is also I have pointed out here.
Where is your requisition? Where is the prayer for that in the requisition?
That is my in IA. But in the main case, my lord, I have stated there, my lord,
No.
regarding that.
That is not your
Loss.
prayer in the requisition.
I have reply. I have given.
Okay, how much cost should be imposed upon you for unnecessary spoiling the books?
In affidavit.
No. You are already, we can. There's no affidavit business out there. You have to go there before the suit. Now, unnecessarily spoiling 10 minutes of the court's precious time. Only, not your client, because again you have done. Now, I know why you have come to save your face before your client.
No, my.
Yes.
No, madam. They have advised me to keep pending this case, madam, only.
Why?
Because, my lord, in
They
view,
will advise you and you will do whatever may be.
they have instructed me because, my lord, in view of the this order, my lord, they have again take.
We do one thing. We restore this and dismiss the retribution. Okay.
Giving that liberty, madam.
No liberty.
Because, my lord,
No,
otherwise they
no
will be
liberty.
more loser, my lord.
You have already been given the liberty.
No, but so far this part is concerned, my lord, other rest of the eviction of the eviction again, my lord, by the forest department.
First of all, you should not have withdrawn. You have withdrawn. Now the second is you have been evicted. Once you have been evicted out there, now the question is for restoration.
Restoration.
You have to file a suit for declaration of your right, title, interest and recovery of possession
Yes, my lord.
against the forest department as well as the revenue department for your declaration of your right, title and interest.
Revenue department already NOC given, Secretary James.
Who is going to help you out?
Revenue department.
So you have to make him a party now.
There are chiefs.
And the forest department,
They are opposing.
they will oppose. So therefore, you have to ask for a declaration against the forest department that you have right, title and interest over this land. And this is not a part of the forest land.
Yes.
This is what is being given to you.
Yes.
Then what is there? Now what? Again, you may say the court has explained to me and therefore I have.
Now, Lordship has specifically mentioned, but in that order earlier it was not mentioned. That is why the trouble.
I'll make it clear. Heard Mr. H. Das, the learned counsel appearing on behalf of the petitioner. Mr. S. Boktaku, the learned counsel appears on behalf of the respondent number 1 and 2. Mr. S.S. Kuyuate, so and so appears for respondent number 3. Forest 4 and 6. And you are for 3 and 5. This is an application for recall of the order dated 11/6/2026, past 5, passed in WPC number 4838/2024. On the ground that the petitioner rights would be on the ground that the withdrawal of the petition would prejudice the petitioner in future proceedings. Okay?
Yeah.
This would have been with the petition, accompanying with petition, wherein the petitioner claims that the petitioner is the owner of a plot of land at measuring 2 bighas. 2 bighas or 5 bighas?
Out of 5 bighas, 2 bighas given to him.
Was the owner of a plot of land at measuring 5 bighas covered by tag number 60 or patta number 67 in the revenue village Othuakuthi, part 4 under Rongzuli Revenue Circle in the district of Gwalpara, Assam. Out of the said land, 2 bighas of land was leased out to one Himadri Das for setting up of a retail outlet of the respondent number 1. The grievance of the petitioner for which the petition was filed was issuance of a notice on 27/8/2024 by the Forest Department. Inasmuch as it is the specific case of the petitioner that the land is a patta land, wherein the forest officials have no jurisdiction to issue the notice. Be that as it may, prior to the interim order so passed by this court on 23/9/2024, the petitioner had already been evicted by the Forest Department on the basis of the notice dated 27/8/2024. Under such circumstances, the remedy of the petitioner therefore lied before the competent court of civil jurisdiction for seeking appropriate declaration of his right title and interest over the plot of land, over his plot of land, and for consequential relief for recovery of possession. This court duly takes note of that while the counsel for the petitioner submitted before this court on 11/6/2026 that he may be permitted to withdraw the petition with liberty to avail the appropriate remedy under law. There was no mention as to why that approaching the appropriate court, that the withdrawal of the writ petition would not prejudice the petitioner in such proceedings. Inasmuch as without such a observation, the petitioner would definitely be prejudiced in subsequent proceedings. Accordingly, this court disposes of the instant application, thereby observing that the withdrawal of the writ petition, accompanying writ petition by the petitioner, with liberty to avail appropriate remedies as permissible in law, shall be understood that such remedies so permissible under law, so that shall be understood that when the petitioner, upon due advice, approaches the competent court of civil jurisdiction, the withdrawal of the instant writ petition shall not prejudice the petitioner. With the above, the ayes may make space. Okay, satisfied?
Self-permission, self-permission was not given. She never was issued to workplace and that was given that guidance of the petition shall not be a ground to consider the
What is the petitioner's application?
petitioner's application is for he has applied for sale permission, Miller. He has applied for sale permission. And that was not given within requisite time. Therefore, we have approached before this Honorable High Court. The High Court on well issuing notice, the High Court has issued notice on 11/3/2026. While issuing notice, there is a direction that pendings of the petition shall not be a bar for respondents for consideration of the application of the petition strictly in accordance with law. During the pendings of the writ petition, the petition was self-permission petition was rejected on the ground that there is a land dispute and geotech photo was not enclosed with the application. We have filed thereafter. We have filed the RTI before the appropriate authorities to disclose what is the what civil dispute was pending and whether geotech whether if the geotech photograph is not even it is curable defect or not. Then and the RTI reply is given in the Millot, IA Millot, page 12 Millot, and it should be. Serial number 5, 6, and 7 Millot, because we can complain objection was received by the.
So your application was rejected. So once your application is rejected, what is there? You have to challenge the rejection.
Millot,
But not by way of this.
But-
No, madam.
But there's a cryptic
You know,
order.
madam, you're thinking it right. You filed a writ petition for the purpose of, on the ground that you have submitted an application for permission, and that permission have not been accorded. Okay? Now, during the pendency, the application has been rejected. Isn't it a fresh cause of action?
Yes, Millot.
So your entire writ petition otherwise has become infructuous.
Just-
So therefore, you need to withdraw and file a fresh writ petition. Then withdraw the writ petition with the liberty to file a fresh one. heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Revenue, so-and-so revenue, and so-and-so appears for respondent number 2, 3, and 4. The present petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in granting the permission, in granting the sale permission for transfer of the land of the petitioner in pursuance to the application by the acknowledgement number NOC/02/58660/2026 dated 3/2/2026. It has been brought to the notice of the petitioner. It has come to the pursuant to the notice being issued. It had come to the knowledge of the petitioner that the petitioner's application seeking sale permission dated 3/2/2026 was rejected. Under such circumstances, it being a fresh cause of action, the learned counsel appearing on behalf of the petitioner submits that the petitioner may be permitted to withdraw the instant writ petition without prejudice and without prejudice to the petitioner's claims in the instant writ petition, and so that the subsequent and fresh cause of action can be challenged. Accordingly, the instant writ petition therefore stands closed on withdrawal. It is observed that the withdrawal of the instant writ petition shall not prejudice the claims of the petitioner in the instant petition, as well as and further, the petitioner would be at liberty to challenge the order of rejection of the petitioner's application dated 3/2/2026 by filing a separate writ petition, if so advised. With the above, the petition stands closed. I close in view down. Yes, what has happened?
Problem with the council because of the elections, and there was a stay order by the scope on the formation of the body. However, interim council has been, interim working has been formed by the Bar Council of India with the Advocate General of Assam, Nagaland, and the member representing our Bar Council.
No, the problem now, the Senate permission, he will continue. Now he can very well practice as.
The enrollment certificate is ready. Only signatures of the Advocate General of Assam, he was on the station.
That is okay. His worry out here is limited. Limited worry that in view of you keeping a 6 months period, that period he has to enroll after passing of the exam, otherwise he has to appear for another exam. So he need not do so.
If you know that period has been extended to 1 because of the problems in the formation of the council. That has been extended to the 1 year. Right?
And as he has already passed the exam, so therefore, on the fault of the BCI, to take steps for issuance of the enrollment notice, enrollment certificate, the petitioner cannot be stopped from practicing.
No. He will get it, madam, and the AIP exam results will be valid. The exam results will be valid, anything extended for a year. But I have the documents, the affidavit is not.
We file an affidavit.
We have not filed. Documents are very flawed.
Unnecessary, we record your submission and close the petition.
File.
What is there?
Submission is there. Except, enrollment certificate is there. Signature is put into dot. But that may be put into consideration.
Which
I have the document, time by, this is a reference. It's okay, the signature is done. The of Nagaland is, except one of things.
it's okay. No, Mr. Chetty, case was one. Then look here. in the admit card, there is a mention out there, as an instruction to the referee, that look here, you have to, after passing the exam, you have to get yourself enrolled within 6 months. And if you don't enroll yourself within 6 months, you have to again appear for another exam. That's your anxiety. Now, he says that the period of 6 months have been already extended by 1 year. One. And secondly, once he has already passed the exam, this has been duly mentioned out there in this document, which is not denied. He cannot be stopped from practicing on account of the fault of the BCCI in not issuance of the enrollment certificate.
And for practicing, you need to practicing and give the certificate. Give the certificate. 10-15 days.
No. Once a person passes the exam, he gets himself enrolled, provision. Within these 2 years, he has to appear in the exam. Once he passes the exam, it is the duty of the BCCI to issue the enrollment certificate.
Yes, ma'am.
The final enrollment certificate. Now, the final enrollment certificate have not been able to be issued on account of the fault of the BCI.
Yes.
So therefore, he cannot be stopped from practicing.
In this case, he has passed the AIP before it. The provisional enrollment he has not taken. He has passed it immediately after passing his LLT.
You have not taken the provisional essay. Provisional allotment you have not taken.
My lord, after. Apply. That is it. For provisional, I have applied to State Bar Council.
Provisional has no problem.
Why not this one? Why not after the LLT exams degree is obtained, why not? He has to apply for it. And whether he has the AIP or not, but he has to pass the AIP within 2 years of the provision.
Now, has he applied for the provisional?
But actually, Lordship, there is no provision for provisional enrollment in our purpose. It is only enrollment. We give a provisional one if he does not pass. In his case, since he has already passed, he'll get the full enrollment.
Understood. You give the BCCI gives 2 years period.
If it is provisional.
It's provisional. Now, the moment he passes, he can very well enroll. And his enrollment is given provisionally.
But why not the enrollment number is not? It's the final enrollment. Only thing is, it would be kept in abeyance if he does not pass. In his case, he has already passed. He has applied just before passing to AIT. So he'll get the full enrollment. There is no problem. We do not issue any provisional enrollment certificate. We simply take an undertaking from them that they would pass the AIT within.
So therefore, when a person passes an LLB, he submits his certificates out there to the authority. The authority permits, on the basis of some undertaking or something, permits him to practice.
Enrollment is issued. The enrollment certificate is issued. After that, he can practice.
After that,
he can practice. Not before issuance of the.
But you have not issued the enrollment certificate. Why?
Well, that was because there was a status quo on the functioning of the backgrounds because of the election. And the special committee was formed in the month of May. There were around 2,500 applications. We have issued the certificates. We have handed them over to about 1,000 of them. About 1,500. 500 is within that. Those were applied up to middle of September. They have already gone. Middle of September. They have already. His application was. Why not? I understand why not. It ought to have been expedited. It ought to have. There was the problem. But that was it is
His right to under 19(1)(g) is effective. Then who is going to compensate him?
Why not? Why not?
Who are you? And you?
Safe.
So he can practice? No. He can practice? My question is, can he practice or not? You have extended to 10 years. I'm not bothered with that. But my question is, can he practice or not? So therefore, your extending has no meaning out there.
But in fact, that is I would admit, my lord, that is the delay in issuance of the certificates.
You impose a cost upon you, 50,000.
My lord, as of now,
With 5,000 per day.
my lord,
Can you
the
go issue?
certificate is ready. Certificate is
Give it to him.
well, we can get, well, this is the copy of the certificate. Only thing is this, since the Attorney General of Nagaland, is it?
Let him pay it from his own pocket. Now, obviously, because of him, if you have chosen a functionary to sign, and that's because of his absence, a person cannot be affected.
The BCI had issued a notification earlier on 14th of May, making the Attorney General and a member of the BCI, of the special committee for all the councils. But since our council has 5 seats, therefore there was a problem since all the 5 advocate generals cannot become members of the team member. We had sought for clarification, and it was clarified then since the office of the council is in Gauhati, the Advocate General of Assam and the Advocate General of Maharashtra.
Then why are you not issuing him a provisional certificate?
No, there is no provision under the Act for issuance for provisional. The provisional certificate would also require.
Then you should have it that first you have the AIB exam, and then only the certificate.
Why not?
That is not your rule. Why you are having the 2-year gap?
No, why not? The normal rule is when they apply for enrollment, they did not have the AIB certificate, but only the undertaking that they would pass AIB.
That is it.
That
That is
is
the
his-
undertaking to issue the certificate.
But in the meantime, he has passed it.
Maybe because of that, allow him now to practice till you issue this.
Why not? There is no provision under which he can do.
But how did you, if he has not passed, he can practice?
No, man.
That is what you are saying.
No, man. No.
You say that if a person passes the LLB exam, he applies out there. You take an undertaking that within 2 years you give your AIB exam and pass out, and if you pass out, then in that regard, during this period you can practice.
He can practice, but after the enrollment certificate is issued, after he gets the license.
Understood. So then you have given him that this is subject to passing of your exam under so and so. Now, why haven't you given that certificate to him?
But that was under process. That was under process, the verification, because as per the Act, Manoj, it needs to go to the committee. The committee was not in existence because of the election. Elections, Manoj, there was another problem. Because, Manoj, the Supreme Court has directed for women reservation. That was not under the Act. It was referred to the Justice Trivia Committee. The Justice Trivia Committee, Manoj, and thereafter the modalities were laid down. Even as of now, Manoj, this issue is not yet finalized. The hearing was yesterday. Manoj, about the co-option of women members. So the elected members have not yet assumed charge of the council. It's a special committee which is. But that was the entire problem. The interim committee has been formed only for that purpose, but only for the purpose of enrollment.
But the petitioner had applied for enrollment.
I have argued for issuance of earlier in the council, the previous council. The argued for issuance of.
But I passed an order on the last occasion. In the opinion of this court, that the clause B3 of the instruction for the candidates stipulating that a candidate has to enroll within 6 months from the date, from the dating of the passing, from the date of passing of the All India Bar examination shall not apply to debar the petitioner from pursuing his practice as the petitioner has already applied for enrollment.
My lord, that is taken care of by this notification of 23rd of June. Weeks back, if you may not move back to.
There are law break.
My lord.
What do you say about the highlighted portion in page 3 of this document? What do you say about it? He comes under category 3. It is further resolved that with effect from so and so and all subsequent bar examination, the same principles shall apply prospectively, unless otherwise modified by the Bar Council of India. The 6 month period shall remain the normal rule. The 1 year period shall operate only as an outer limit for categories 1 and 2. In objectively verifiable cases where candidates are unable to complete the enrollment formalities within 6 months for a reason not attributable to the candidate. Category 1 and 2 are those who have not passed.
Not pass.
Category 3 candidates who have already obtained the degree, final mark sheet, so and other so and so for enrollment shall remain bound by the period of 6 months.
But in this case, my lord, is that this was, my lord, to enable those who are in the final semesters or the final years to apply. In his case, my lord, the result was out. He had already applied.
Understood. My question therefore now is he has already passed. He comes under category 3.
He comes under category 3, but the benefit of category 1 and 2 can be given to him.
How?
Why not? Because
No. Is it on the basis of other submission? Because this is not what it has been mentioned here.
but my lord, this was the practice even last. Even last year, we had faced this problem, my lord. there also this period of 6 months was fixed. Last year also it was extended on the basis of a similar. It we had given.
No, but this was issued now.
This has
So-
been issued now.
So as of now, there is no notification as regards the cases of
My lord,
petition.
on the basis of this, the instruction is that we can get through that. That his enrollment would be valid, my lord, on the basis of this particular. Because he has already, though he has already,
But this notification cannot be applied to the petitioner.
my lord, who has not yet enrolled, that is, if we read, my lord, category three.
Category 3 candidates who have already obtained degree,
Yes.
final mark sheet, provisional degree certificate,
Right.
or other final qualifying university certificate necessary for enrollment shall remain bound by the period of 6 months. Now kindly see the category 3 who are
Right. In the first.
law graduates who have not yet enrolled with any state bar council and who had obtained or were required to obtain their LLB degree from a bar council of so and so approved by the Bar Council of India and affiliated with the Bar Council of India recognized university. So he comes under 3.
He comes under three in by reading of this, but he had applied for it. Who have not yet enrolled. The enrollment part is on the council. He had his part role is only to apply for it. Since he has already applied for enrollment, the fault was on the part of the council in not issuing. Therefore, he has to be given them. He would come under 1 and 2 thereby. On a
One would not come in.
Mother, because yes,
One is, you have specifically defined who is one. Final year or final semester year having no backlog.
it's
Those who candidates who have completed the final semester examination with no backlogs and are awaiting the final results.
fine.
Here is the person who have already passed.
He has already passed. But my lord, he who has not yet enrolled, that is category 3. But he has applied for it. Since he has
So
applied for
therefore,
it.
you say that this notification would not apply to him.
No, my lord, it will apply.
No, it cannot apply because he does not fall in either of the 2 category.
My lord, the reason is this. Since he has applied for it, that we
See, category 1 is those who have not passed. Category 2 are those who are awaiting results. Category 3 are those who have passed but not enrolled. And category 4 are those persons who are not enrolled but are in service. Okay, 4 is out, 1 and 2 is out, now comes 3. Now he is not enrolled. He has applied for enrollment. So once he has applied for enrollment, so 3 he won't come in. So if he doesn't come under A 1, 2, 3, 4, on what basis are you saying that he will come? He will be granted 1 year.
My lord, we are doing it along with one.
It is verbal.
And that was in fact, my lord, this would be my
That is
submission. as well.
verbal. That is what I'm saying. This won't apply.
My lord, but my lord, that can be recorded as my submission.
How?
My lord, that was the
So
practice.
therefore allow him to practice so if you do the submission.
My lord, this the other flag is his enrollment.
Huh?
The other flag,
Give it to him.
My
One
lord,
person signs.
the signatures of the.
Signature has not been signed.
My lord, 10, 15 days. My lord, may just have a look.
I have
The
looked
one
into
signature,
this
we
is
can
not done.
obtain it today.
No, this is not what is expected.
Well, one signature can be obtained.
Absolutely. Absolutely.
I understand.
This court had issued notice on 10/6/2026, directing the respondents to bring on record their stand by filing their affidavits. However, no affidavits have been filed on behalf of the respondents. Mr. P.D. Nair, the learned senior counsel, assisted by so-and-so appearing on behalf of the Bar Council of Assam, Nagaland, on behalf of the respondent number 1, submits that on account of the non-availability of the Advocate General Nagaland, the enrollment certificate which have been already printed have not been, could not be passed on, could not be handed over to the petitioner. The said submission therefore makes it apparently clear that it is on account of the fault of the respondent number 1 that the petitioner have not been granted, have not been issued the enrollment certificate, though the petitioner deserves. He submitted that the learned senior counsel submitted that within 15 days, the said certificate would be handed over to the petitioner. This court duly observes that on account of the inaction on the part of the respondent authorities, more particularly the respondent number 1, the petitioner's rights under 19(1)(g), as well as the right to life with right to livelihood, has been affected. Under such circumstances, this court observes that if the respondent number 1 fails to issue the certificate to the petitioner, enrollment certificate to the petitioner within 15 days from today, certain alternative measures be taken by the respondent number 1 so that the petitioner can start practicing in the courts, in as much as on account of their inaction on the part of the respondent number 1, the fundamental rights of the petitioner cannot be put in jeopardy. List this matter on 7th of August 2026 for an update. We have no rule. Much obliged.
May I plead the lordship? Madam, kindly peruse the office note, madam. There is some problem, madam. We have taken steps, madam, but it shows that we have taken steps only for record number 1 to 5.
Why you have not taken steps to 1 to by usual process?
We have taken, madam.
The usual process is not necessary.
I will check today, madam.
No, not necessary. You are doing for
1, 2, and 5.
1, 2, and 5. This is pertaining to what?
Another one, another DB stock broking, one scam was there. DB stock broking. That's what I have understood from the plain meaning of the repetition. They had invested some amount to DB stock broking. And this was again sent to police investigation, and all the accounts which were connected to all this stock broking.
My issue is that my petitioner's bank account has been kept on hold from last 2 years now. That is the issue, madam. Without serving us any notice, madam, and without following the SOP, which has been published by the cyber criminal.
How many banks?
3 banks, madam.
3 accounts, 2 banks, 1 State Bank and 1 HDFC.
Who is paying for HDFC?
Right.
1, 1, 3, 1,
1, 2, 1, 2, and 5. 1, 2, and 5.
You have not taken steps
But I have taken, madam, something went wrong, madam. I have taken, madam. What
by
happened?
speed post.
Yes, madam. But I'll check today, madam. What happened? I have taken, madam.
You are paying for one,
1, 2, and 5.
for State Bank. Were you not effecting service upon respondent number 4 by way of the, you have a count in this one,
Yes, madam. Yes, madam.
effect service upon respondent number 4 by Dusty. And what about the steps upon respondent number 6 to 13? Why haven't you taken steps?
I'll check today and I'll take it by 14,
Huh?
2, 3 days, madam. I'll check it today. What
No,
happened?
you have no urgency.
I have taken, madam. I'll not tell,
No,
madam.
you have no urgency. You have not taken steps upon the respondent numbers who are 6 to 13.
Kindly see, madam. Madam, we have taken step, madam. Madam, my learned friend has also appeared. How come not only response number 1 and 5 has been issued, madam? That I'll check, madam.
Here it categorically mentioned that
Yes,
no
it has been
steps were
mentioned.
taken
I've seen-
upon 6 to 13.
I've seen that.
Then
But I'll check it.
you have no urgency. The office records reveal that no steps have been taken upon the respondent number 6 to 13. Further to that, service upon the respondent number
1 to 5.
3 and 4 is yet to be complete. Mr. So-and-so appears on behalf of the respondent numbers 1, 2, and 5. Taking into account the above, this matter upon service being complete. Mr. A.K. Sahiwala, the learned counsel, appearing on behalf of the respondent numbers 1, 2, and 5, shall bring on record its stand by filing the affidavits on or before 5th of August 2020.
Lordship may also mal call that back report of forest number
No,
3 and 4.
absolutely no, I'm not, you are not interested in your matter. Therefore, I'm not fixing a date. I fix all dates. This matter will come up in 2029.
The prisoner will seriously injured, madam.
What?
The prisoners will be seriously injured.
Therefore, my question is, the council should have been in a much better place. Why haven't you taken steps upon respondent number 6 to 13? Why?
I'll check it, madam. Let's check what happened.
So then this court can't fix it. I have to fix after 1 month. Then post the matter again on 19th of August 2026 with an update as regards service upon the other respondents. Petitioner would also be at liberty to file reply to the affidavit filed by the respondent numbers 1, 2, and 5 on or before the next. Yes, what is this?
May I please your lordship? Lordship, the petitioner unable to furnish any other address of respondent number 4 and 5. Therefore, Lord,
Item number?
50.
Then
Lordship, may kindly
your matter about, let us see. The respondent number 5, can we finish it?
4 and 5.
Are you? What is your case? Madam, argue.
Lordship, on 27/6/2010, the petitioner was appointed as booth level officer of polling station Nong 114 under number 85 Rupahi Hat Legislative Assembly constituency by the respondent authority.
Then
And subsequently on 30/4/2015, the
Now,
petition.
what is this booth level officer?
NRC lordship. In 2009 lordship, when it was in the final stage lordship.
Now NRC is no more.
His lordship
Then
is
what is there? Unless it is, therefore your person must have been here. There is no longer any requirement for a booth level officer. As such, we are directed to a booth level officer. NRC finished well. The present petition has been filed by the petitioner, challenging the termination of the petitioner's appointment as a booth level officer and the appointment of the respondent number 5 as the booth level officer. Ms. M. Bhattaji, the learned counsel, is appearing on behalf of the respondent numbers
1 and 2 lordship.
1 and 2, submits that these booth level officers were appointed at that point of time on account of updation of the NRC. And the process of the updation of NRC is no longer there. And as such, no effective directions can be passed in the present proceedings. This court have also taken note of that at present there is no steps being taken for any updation of the NRC. And as such, it is the opinion of this court that no effective writ can be issued in the instant proceedings. Accordingly, the instant writ petition therefore stands closed. What it is?
That is a lot. Lord, there is a specific order passed by the learned executive magistrate.
Huh?
Madam, there is an IML.
What case is this?
Lord, kindly, my lord,
You are the writ petitioner.
Madam.
I give main. What about I? What is your case?
my lord, there is an order passed by the learned executive magistrate to clear up the path. My lord, I want to take your lot.
Who is in possession?
Position, my lord, to clear up the.
Who is in possession of the land? The executive magistrate coming into picture means it is a case under 141, 145. So there is a second party.
Well-
Where is the second party in the writ petition?
In the petition, second party, my lord,
Not
8 and
there.
9. 8 and 9, my lord. Private
What?
respondent.
8 and 9. When did you make him a party?
After filing of the writ petition, my lord, implement petition has been filed. And after that, my lord,
So it is a dispute between you and 8 and 9. Civil court? Not. Take help of all these executive orders, magistrate's orders. Right title interest, recovery of possession.
your lordship is
And-
aware, my lord. I am fighting, my lord. For the more than decades, my lord.
Civil court. No?
And
What
my
do you
lord,
say, Mr.
my lord,
Lawyer?
one thing,
Eh?
my lord, one,
No, this court is not going to do all this.
my lord, one thing that should be,
Possession, no possession, whatever may be, police knows what to do, what is there. The police has to take action, the police has not taken action, then it is your recovery has been done to the police or go before the executive magistrate to do all this thing. The court is not going to issue a writ for.
My lord, executive
It's a
magistrate,
question of possession. Who is appearing for response number 8 and 9? 8 and 9? Yes, what is your stand? Take the mic with you towards you. Yes.
I have my instruction from senior next on another court.
Who?
Ahmed.
So?
my lord, specific order to clear up the path, my lord, that has been used by the petitioner for ingress and egress. And in spite of that, my lord,
Understood, but this court cannot do that. It is for a civil court to do it.
exactly, my lord, after filing of the petition, my lord, there is a subsequent development, my lord. Both the parties are called and both the parties appear before the, my lord, circle officer. Circle officer has taken, my lord, undertaking that they will vacate the second party, 8 and 9.
So
And
these are
some-
good grounds for you. Get an injunction there, not to disturb you. To your ingress and egress. That is how you do it. You disturbance, yeah, all these things, you don't do it that way.
I have been, my lord, dispossessed, that's why I also.
So they take a 144, 145, 145, 146. Then you come over out here.
Six
The
of the
order has not been complied with, as if you see that this court is a executing court.
no, my lord.
Then,
Respondent
yeah,
authority.
what do you want? A dismissal? Withdrawal? Which one? It is
I have the my lord
10
respondent.
minutes. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers. Revenue, Ms. So-and-so has been appears on behalf of respondent number 1. Mr. So-and-so appears for respondent number 2, 3, 4, 5, and 6, and 7. Ms. So-and-so appears on behalf of respondent number 8 and 9. For a perusal of the materials on record, it is apparent that there is a dispute of a civil nature between the petitioner as well as the respondent numbers 8 and 9 in respect to the use of the path, wherein there were certain directions issued by the executive magistrate. It is the opinion of this court that the petitioner would be well advised to approach the competent court of civil jurisdiction, inasmuch as this court, in exercise of jurisdiction under Article 2 to 6 of the Constitution, is not inclined to entertain a pure dispute, civil dispute between the petitioner and the respondent number 8 and 9. Accordingly, this court is not inclined to entertain the instant writ petition for which the writ petition stands dismissed. Before parting with the record, this court makes it clear that taking into account that this court has not entertained the dispute, the dismissal of the instant petition shall not prejudice or preclude the petitioner to approach the competent court of civil jurisdiction or the jurisdiction in respect to the path which is the dispute between the petitioner and the respondent number 8 and 9. Close. I close. What is this? 20?
We are challenging the rejection of our technical bid, my lord. This was moved during vacation, my lord. Lordship was pleased to issue notice on motion.
Direct
well.
the
And we had taken steps through mail to private respondent, my lord.
What?
I have instructions to appear on behalf of the respondent number 6, my lord.
Okay.
So, but would it be that the entire petition was not served, but only the petition was served in full and the annexure?
Well, sir, my lord, I have given a scanned copy which is there in my mail, my lord. Your lordship has permitted me to send it through mail provided by the railway council. my lord. I'll provide in one case.
Okay, open the mail and show it to him,
My-
whether the entire thing is there.
Yes, sir.
See? Open the mail and show it to him. If the mail contains the entire along with annexures, not necessary.
Yes, the PDF will be a file will proceed online.
Show it to him. No, not that document. How will I understand that the PDF is of 234 KB or 1 MB?
Blood 6501 KB, blood there. In the mail, the attachment is there.
You have sent the email,
My lord, yes.
and in the email it will be there.
Yes, yes.
Show it to him whether it is a part has the enclosures or not. If it is has it. Oh. In the meantime, show it. Let me finish it with Mr. R.C. Saikia. Yes, Mr. Saikia. Wait, Mr. Dubey, both of you,
Yes, yes.
just take it. Mr. Saikia, you have received the money. You have received the money.
I have informed me.
Yes, the amount has been paid to your account.
This is because of your lordship's interference. After long 25 years, the party has got the relief. And we are very much obliged to your lordship.
It's okay, but have you received? I think you have received your money.
But
We do it. You give a call to your clients
I will give a call to them.
just now, and we'll take it up at 2.
My
You
lord,
just let me know.
my lord,
Okay? Because they say that they have already made the.
my lord,
It will be seen out there in the. It has already been given.
my lord,
We'll take it up at 2.
my lord.
Okay?
Yes, oblige me.
Yes, Mr. Dubey. Is it there or not?
My instructions that my.
No, forget about the instruction. That email is there, and forward that email to him.
Yes.
To his address. Service complete. Now come to the point.
They're challenging the.
We have in Gauhati High Court also we need to be more advanced like Delhi High Court. Delhi High Court goes by airdrop. We let us still have it by email.
But this was my instruction.
Now that instruction is taken care of. Now what do you want?
My lord,
You file your reply.
I will find it.
You are filing your reply. Filing your affidavit. There is no interim order?
No.
So do we need to take it up urgently? So we have it on 7th of August. What are your technical bid has been rejected?
Yes.
And what is the present status when there is no interim order? Contract has not, so if the contract has not been allotted till date, we have it on 23rd of July. In the meantime, don't allot the contract to anybody. You file your reply by 20. She has already filed. You want to file a reply, you file your reply by 21st. And on 23rd, we take it up for filing.
Can it be a day earlier or later? I have a matter fixed at Itanagar.
Oh, that means you are not in urgency.
No, Lord,
We
I have
have it in
urgency.
the month
Lord,
of,
I am seeking
we have
an
it in
earlier
the month
date.
of December.
Lord, I am seeking an earlier date,
No,
Lord.
no, December.
Then
This,
Lordship may take it
7th of
23rd.
December.
Lord, I'll have to miss that. Lord,
7th of December?
Lord, 23rd. I'll go down to you, Lord.
The matter is urgent.
Yes, yes.
I'm fixing it on a Tuesday,
Yes, yes.
then Thursday, so that we can finish it up.
Yes.
Because I'm passing an interim order. You don't want an interim order,
Yes,
then
yes.
we can have it
No.
on any other day.
No.
No, don't allow it now. Do it now. Because otherwise, again, the problem arises. That is why I'm fixing it on 23rd.
Well, it will be subject to outcome.
What subject to outcome? Then again, you start out there, your work. What is the work for?
Well, it's,
Work for what?
well, it's for, upholstery and my lord, a lot of components are there, my lord.
Huh?
My lord, linen, supply of linen, then my lord,
Okay.
upholstery, my lord.
You supply at your risk and cost. You supply at your risk and cost. And if you lose, you can't ask money from them. You give an undertaking. No problem.
Look, there is a clause for setting up a laundry which cannot be done in a short period. Once they will set up, then only the supply would be. And
In fact, my lord,
Then okay, setting up local store. For which one?
page 26, your lordship.
What is the contract for? Let us see.
Page 26.
my lord, the name of the contract, my lord.
Page 40 would make it clear, my lord.
Okay, turnkey contract for work of supply, installation, commissioning of plant equipment and related infrastructure and operation of mechanical laundry and other goods. Collection of solid linen from coaches from so and so, so and so, so and so. And loading of washed linen into the coaches of Agartala, so and so, so and so. Now, why it was been rejected? Your thing has been rejected?
Blood, because blood, there is a, blood, they say that a requirement is there for liquidity. There has to be a bank certificate, blood. That bank certificate has not been certified by the chartered accountant.
And they required the certificate from whom?
Look, from the bank.
You have filed your affidavit to do. You have a copy. We'll have it at 2. Your affidavit will do. We finish it off today itself.
Blood,
Today also.
I'll have to go through there. There are two. Anyway, blood, lots of
We'll finish it off today itself. Your only point is the certificate. The certificate was the basis reasons. They say the certificate should have been with the charter accountant. Whether it was the requirement of the notice that it should have been a charter accountant or not.
Blood, they have produced a letter before your lordships on 1/7. Blood. And blood, they say that they have been served to on us. There was a direction for them to blood, show whether they have served. Blood, they have taken 2 grounds. Blood, so far as our information, blood, our technical bid was rejected because of that. But in that letter, they indicate that I am not technically qualified, whereas I have submitted all my documents. Blood, I have
So
demonstrated.
2 o'clock,
Yes, yes.
you get your copy of your affidavit. You don't require. Mr. Saikia, have you received your money? Okay, we close the content. The content today. Heard Mr. Ashish Saikia, the learned senior counsel, with by so and so appearing on behalf of the petitioner. Mr. B. Gogoi, the learned additional AG, appeared before. Additional AG appeared on behalf of the respondent.
4 and 5.
4 and 5. In pursuance to the order dated 19/6/2026, the amount of rupees 13,78,030 rupees have already been paid, transferred to the petitioner number 4's bank account. Huh? Petitioner number 3's bank account. Taking into account the above, nothing further remains in the instant contempt application. Mr. R.C. Saikia, the learned senior counsel, appearing on behalf of the petitioner, submitted that the calculation has been wrongly, have not been made in terms with the judgment passed by the reference court. It is the opinion of this court that these aspects can be very well taken up before the executing court if so advised. Accordingly, this court does not find any further requirement for continuation of the contempt proceedings, for which the contempt proceedings stands closed without prejudice. Before parting with the record, this court observes that the closure of the contempt proceedings shall not prejudice the petitioner to approach the executing court if so advised.
Oblige, Doctor.
Yes.
But I have been served with a copy of the affidavit. My lord.
But there are two reasons.
Yes.
The first reason is for the purpose of that you did not have the similar work.
Yes.
And the second is that you T2 eligibility or liquidity was not
Yes.
submitted as per the tender.
Yes. Yes. Yes.
But now let us see as per the T2 eligibility document.
Yes. First, I'll draw your lordship's attention. Page 52, 53, my lord. The financial criteria, it starts as with 53 clause 1.3 if your lordship have it. But there no issue as regard A.
Tenderer shall submit requisite information along with copies of the balance sheet.
Yes, that
duly
all.
certified by the charter accountant. Public certificate from the charter accounting duly supported by the auditor.
Yes,
That you have done.
my lord, kindly come page 54, clause B is the issue.
The bidder should have access to or to have available liquid assets, lines of credit in other financial means to meet supply cash flow that is valued at 5% of the estimated net area income to be submitted as per annexure 10 and 11. 20 and 21. Where is annexure 20 and 21?
My lord, kindly come to page 215. Before that, I'll show you lordship from the annex document. At page
20.
Yes, but page 156, if your lordship kindly take.
20 is 155.
Page 56, 156, madam. 155.
155.
Annexure 20.
To certify that so and so is a reputed company with good financial standing and so and so, so and so, so and so. Signature of the bank.
Yes.
Change the text as follows for joint venture. You are not a joint venture.
Not joint venture.
So you are to give as per 20.
20.
You have given.
I have given, but this annexure does not specify that there has to be a certification by the CA. Now your lordship would kindly turn to next page. This is annexure 21, financial data. Because it has to be by the CA, and therefore your lordship at Roman 5 lordship sees at the bottom on the note. The above annexure shall be duly certified by the chartered accountant company auditor under signature of stamp of memorandum.
So you gave this.
Yes, I have given. At that I'm showing your lordships from page 215 and 16.
200,
15,
50,
This is the financial data. Lordship would kindly look at column number 8.
He doesn't have a 250,
215, my lord. I'm sorry.
215. This is given by,
The chartered accountant.
how do you know?
NSS Associate Chartered Accountant at the top at 215.
The chartered accountant.
Yes, yes.
How do you
NSS.
know?
Your lordship would see the next page. It's a continuation of same annexure as page 216.
Okay. So you gave this.
Yes, my lord will kindly come to Roman A, serial number 8 at page 215.
Hmm.
Lordship sees its liquidity. It is to the tune of 7 crores 15 lakhs. The tender is valued at 182 crores. 5% is 9 crore 11 lakhs. If I meet the criteria of 9 crore 11, my lord, I need not give even bank certificate. That is the stipulation. Since so bank certificate become optional if I have that liquidity.
No, but this certificate has to be given by the.
CA, I have given. So
Then
here I don't meet the liquidity criteria. Therefore, I am required to give in addition bank certificate that your lordships find at page 214.
where is it necessary? Where is it mentioned?
My lord, it is in the criteria. My lord has seen page 54. If your lordships read, in case the net current assets from the balance sheet are negative, only the banking reference will be considered.
Where?
At page 54, liquidity clause.
Then the audited balance sheet of banking certified by year with the stamp or statement shall be submitted by the bidder along with the bid.
Yes.
Banking reference will contain in clear terms the amount that the bank will be in a position to lend for this position, so and so. In case the net current assets as seen from the balance sheet are negative,
Yes.
only the banking reference will be considered.
Otherwise,
Aggregate of the net current assets and the submitted year will be considered. But you don't have the 5%.
I don't have. That's why I have given bank certificate. Now, bank certificate is a requirement by the bank, my lord, where the bank will certify that yes, I am ready to give.
Where is it mentioned out here?
My lord, in the my lord, annexure, which is the format at page 240.
In clause D,
Yes.
wherein it says that if you don't have 5%,
Yes.
then you can give a bank certificate.
The banking reference, therefore, banking reference should contain in clear terms that the amount that bank will be in a position to lend to this work. And if I have a negative liquidity, so it will go. So either by my net current assets or with banking reference, I should be in a position to give 5% of liquidity.
No, it doesn't say so.
But I'm not relying upon my balance sheet. I'm showing this to your lordships only for the purpose where there is a requirement that it should be signed by the chartered accountant, but the stipulation is already there in that said annexure regarding financial statement.
Now here its liquidity is how much? 7 crores 15 lakhs.
Yes, so I'm not fulfilling that 9 crore 11. Therefore, 214 certificate I need to give by the bank. They say that it should be also certified by the chartered accountant. Only chartered accountant.
First of all, the bank certificate is required to be given. Which certificate?
Bank certificate for reference and liquidity. The format your lordship has seen at page 155.
Okay. No, understood. This is 20.
Yes, 20.
Where does it say that if you don't have 5%,
My lord.
that the bank can give that certificate?
My lord, for the purpose of the tender, I need to have a liquidity of 5% of the value of the
Let us
tender.
again read.
Yes.
The bidder should have access
Or
to
has
available
liquid assets, lines of credit and other finance to meet the cash flow that is valued at 5% of the asset. So if I have net asset value in my balance sheet to the tune of 9 crores, that would suffice.
So therefore, you say that this certificate could be either 20 or 21.
Yes, if 21 is completed, I don't need 20. But I am not meeting my criteria in 21.
So you meet
Bank
under
reference.
20, and 20 does not presuppose the certificate issuance of anything by the
Chartered accountant.
charter.
I am obliged to your lordship.
That's your submission.
In support of this, I have one more submission to make,
Wait,
my lord.
wait. So this is the 20. So you say that if you give 20, or
Yes.
in other words, if you give 20, you
Yes.
don't need to give 21.
Yes. No, 21 I have to give because balance sheet and all audited financial I have to show. But if I have 21 and I fulfill criteria of 5%.
No, here for the purpose of other thing is okay.
Yes,
The bidder shall have access to or have available liquid assets,
Yes.
lines of credit,
yes,
and other financial means to meet cash flow that is valued at 5% of the estimated bid value net of the so and so for other contracts.
yes,
So this is as per 20 you have to give.
yes. Now your
Now,
lordship
in the
read the
sub-
next line.
No, in the, yes,
The audited balance sheet and or banking reference
and all.
and or. So if I can
Certified
complete,
by the charter account code, which stamps so and so shall be submitted by the bidder along with the bid. So therefore, my question is,
yes, ma'am.
you may give that audited balance sheet you have to give.
I have to give.
That is as per A.
Yes,
And or banking reference certified by the charter account.
my lord.
The banking reference is
Annexure 20.
so they mean to say when they mention that banking reference certified by the charter accountant with her stamp
Yes,
means that this banking reference document which is at 214
yes, my lord.
should also be certified by the certificate
My lord.
charter account.
My lord.
That's the context.
That's their contention.
Although 20 does not
Stipulate that.
conceptualize that there is a requirement of signing by the charter account.
Yes. Yes.
That's
But
it.
in support of that, your lordship would also see page 251. But because I am a contractor based in South, my lord, and I am doing works of South Central Railway, but they have issued one clarification in 2019 itself. As regard clause number 2, your lordship would see the underline. The audited balance sheet certified by the chartered account with her stamped signature and membership number and or banking reference. So my lord, there also that understanding was, my lord, that,
So you may know, in other words,
my lord,
the audited balance sheets, which is there,
yes,
has to be certified by the
Milord,
charter account.
I am
Because
deeply
that is
obliged,
the
your lordship.
requirement
Yes.
as per A.
Yes,
And or banking reference which is being given need not be, is
Certi-
not required. But
certification by-
merely by using the word certified by the charter accountant makes it ambiguous.
yes, my lord. I am
And for
obliged, my
which
lord.
it cannot be rejected.
My lord.
That's your submission. Okay, next.
This is my first. Second,
Similar work.
my lord, similar work, if your lordship would see, my lord, they have laid out the requirement under various forms, annexure 12, 12A, 12B, 12C. What the respondents had highlighted, only in respect of one certificate that is there in the prescribed format. Just I am showing your lordships, my lords. If your lordship kindly take
With a capacity of 4 ton. Where?
page 193, if your lordship
Now,
sees.
where's the clause
Yes,
of similar work?
my lord, it's page 51.
Yes. Which one?
My lord will see technical criteria 1.1, my lord. As proof of technical experience competence, the tender must satisfy the following criteria. Should have setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift while washing minimum of 4 tons of linen per shift for a continuous period of 12 months in the qualifying period, current year and previous financial year. So, my lord, what are the categories under which I can avail the service? Now, your lordship would see the note. For the purpose of technical criteria, a mechanized laundry unit shall mean a laundry facility installed in a single premise. Now Lordship would see, for substantiating the requirement of having washed at least an average quantity of 4 tons of linen per shift in one site for a continuous period of 12 months in the qualifying period, that is current year and 3 previous financial year, the tenderer shall be required to furnish documentary evidence as per Annexure 12, certified by one or more institution client mentioned in part para 1.1. It shall be noted that only information submitted in Annexure 13 will be considered. Documents in any other form like letter of acceptance, so and so shall not be considered. Now your Lordship would see the form 12. It is at page 193, my lord, page 144.
Experience certificate.
Yes.
Okay. Now. And annexure 13,
Yes, Annexure 12.
12 and 13.
12, 30, 12, 12A is also there. I'll show you. Your Lordship, kindly have a look at page 145. First, I'll show your Lordship the annexure in the tender document itself. But page 144, Annexure 12 says that these are the requirements you have to address. Now, your Lordship, kindly turn to page 144.5. Here, there is an identification of a single mechanized laundry. So here the format is different.
But that has nothing to do with note Roman 2.
12.
Note Roman 3 is for annexure 12A.
Yes.
So note Roman 2 has only for
But
this.
what their contention in the affidavit is, though it's not very clear, they say that in my certificate, which is I have annexed in terms of 12, I have not mentioned as regard setting up of my laundry. But there is no requirement as such. That requirement has to be read from other annexures, which I have provided.
Which is, therefore, it is note 3.
Yes. My lord.
Which is 12A.
My lord, my lord.
That's your contention.
Yes, yes.
Let's see the affidavit. As proof of experience in similar work as required under the tender contract, you must submit an experience certificate relating to execution of the contract hearing number so and so. The states have revealed the petitioner has only supplied new linen and carried out leasing and distribution thereof. Of setting up and operating a mechanized laundry did not form a part of the scope of the work under the LOA 3. Therefore, the experience claimed by the EIA cannot be treated elsewhere and so. Essential to the function.
There are further
Which
annexures.
is this? 267. The document annexure 12.
Yes, my lord.
No. This the one.
214.
No, no,
193.
no, they have enclosed some documents.
Yes, yes. That is my 193 page, my lord.
Huh?
What I have annexed me a writ petition at 193, 267 is the same.
267.
Yes, in the affidavit. And your lordship would compare with 193.
But they say, let us see 193. Yes. This is the document. This is as per
Page 144, my lord.
not as per that agreement number, date, name of the agency. Name of the
Look, here what has happened from I have to obtain this certificate from my clients. My client has, they have also sought
This
for,
is not as per the format, na? Your certificate is not as per the format.
my lord, it is as per the format, my lord,
Now
at
kindly come to,
page
now
144,
kindly see 144 and 193.
my lord,
Come to serial number 2.
my lord.
Name and address of the organization issuing the experience certificate. Where
Yes,
is
my
it?
lord. But it has been issued by the director. It's a certificate.
Where is it?
But at the bottom, lordship would see.
Where is it in the format? 193.
My lord.
Name and address of the laundry operator to whom this certificate is issued. Name, address of the laundry premises. That is also not in format.
Only some,
Address of the number 4 is there.
but it has
Number 2
interchanged, my
and
lord.
3 is not there. 2 and 3 is not there. Then agreement, the number and date. That is also not there.
My lord, I am the laundry agency, my lord, Leotech process.
Understood, but this is not as per the format.
But serial number only has changed, my lord. My lord,
Where is the name and address of the organization issuing this experience certificate?
at the bottom, lordship
No,
would
no,
see
not the bottom.
director of medical education. They
No,
have
no,
with a seal and signature they have given.
Director of Medical Education, whole government, so and so, Andhra Pradesh.
And in fact, my lord, the railway authorities has also sought a clarification from them. And the director of medical education has also, my lord, sent a clarification, my lord. But what their contention is affidavit is that it does not reflect as regard the setting of the laundry and the machine, which is not required in this.
No, 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 per day washing capacity
Yes,
is 15,300.
my lord,
Is how much? 15 tons.
my lord,
You need 4 tons.
my lord. And I have given more certificates. This is only one of them.
No, you need only one only.
But I have given many. And in other formats, I have also
Wait,
detailed.
wait.
My lord.
Now this is 13/6/2000 here. This is not in Annexure 12. Oh, experience. Here.
Experience, sir.
No, here you have 195 is the 195 is by that one. It is 195.
My lord,
Name of the work.
my lord. But this is
Agreement of so and so. Yes,
this is,
this is the document.
this is other certificates. I have
Understood.
yes.
So this is the other document.
Yes.
Agreement of so and so. This is as per format. Due completion, so and so, work completed, but final measurement amount none. Work completed, so and so, it is going on. Is it going on?
That option is also there.
Now, why is it blank?
But if it's not completed, it's going on.
No,
there.
it can't be because the period of contract is for 2 years. Certificate was given in 2025. Then
This is by the railway authorities. Lordship would also see 197.
197. Number of extensions need. Work so and so. Work completed, not applicable. Percentage. Here it does not given details of warning lunch per day is 4.18. Okay. Now I think 197 document can be the document.
My lord. But from the DME, they have also sought clarification. Railway authorities. The DME has also clarified that we have executed that work.
Yes. What do you say on this?
As per the tender condition, at page 28, lordship,
Page
page 28, already lordship has seen this condition.
28 or 51?
28. Same lordship, but 28 is
28 is sought tender notice.
tender notice.
Yeah.
Lordship may kindly say, the bidder should have access to or has every liquid assets.
Page 28, where?
Lordship first column. Lord.
should have access to or have available
Yes.
liquid assets.
Liquid asset, lines of credit and other financial means to meet cash flow that is valued at 5% of the estimated bid value net of applicants' commitments for other contracts to be submitted as per Annex 20 and 21.
Yeah.
The audited balance sheet and or banking reference certified by chartered accountant with her stamps, signature and membership number shall be submitted by the bidder along with the bid. Banking reference should contain in clear terms the amount that bank will be in a position to lend for this work to the applicant, member of the joint venture of the consortium. In case the net current assets as seen from the balance sheets are negative, the banking references will be considered. Otherwise, the aggregate of the net current assets and submitted banking reference.
And this I have read it.
So Lordship, yes, Lordship.
No, this I
Lordship.
think you are wrong.
Lordship.
I am on the other one.
Lordship, since his balance was current assets was
No,
negative.
no,
Lordship.
he has given a banking reference
Therefore, he has submitted the banking certificate.
of 9.2 crores.
9.11 crores. Lordship.
9.20 crores, he has mentioned it. But that
Now-
is okay.
Lordship,
Now, on the
now,
basis that it is not certified,
yes, Lordship.
that cannot be the ground.
Lordship mechanism page 33. 11% is the page 34. This is the checklist and other details for documents to be fulfilled or submitted by tenderers. Here it is specifically stated, Lordship, mandatory documents, non-submission along with the bid will lead to summarily rejection of offer. So 34, Lordship. You are concerning 34, first column, Lordship. Financial standing. As per clause 1.2, page 24-25 of the special condition of contract, T2 liquidity. T2 minimum 5% of the estimated bid value, that is 911. Third Lordship, T2 audited balance sheet and or banking reference certified by chartered accountant prepare something. So this is Lordship.
That I've understood.
Lordship.
Madam, you don't have a case on that. Come to the second point, whether you have a case.
So as per this checklist, Lordship, this is mandatory.
He has given it.
Yeah. No, Lordship.
Yes. He has given that
He has
document.
submitted.
Because you see, madam, kindly come to 155.
He has submitted the bank certificate, but without the seal and signature of the submitted.
My question is, the seal and certificate has to be given as per your format. You cannot have the banking certificate on one hand, you say that certificate of banking reference you are categorically mentioning here. Kindly come to page 155. One 155 does not contain the requirement of a certificate because obviously the chartered accountant cannot stamp over it. Can the chartered accountant say that the ICICI Bank is going to give it? When the ICICI Bank comes up and says that I am going to give it,
But let's say as per the tender.
that I've understood. Next, come to the next point.
Next one is page 28. Again, Lordship.
Page?
Page 28.
Ah. Yes.
Second.
As
Lordship.
proof of technical competence here, the tenderer must satisfy the following criteria. Should have setting up of a mechanized laundry of minimum capacity of 4 tons of linen per shift, while washing minimum of 4 tons of linen per shift for a continuous period of 12 months in the qualifying period, that is current year and previous financial year. In the above case, the laundry service should be rendered to one or more of the following establishments. So it's okay. Now, what do you want?
Now, Lordship, definition of similar work. Similar.
Should have setting up of a mechanized laundry of minimum capacity of 4 tons of linen per shift, while washing minimum of 4 tons of linen per shift for continuous period of a month. Current year in month. In case the laundry service should have been rendered to one or more of the following year. So this is okay. and tender document here. Now let us see the next document here, submission of the checklist.
Lordship, he has submitted the experience certificate by the medical, Andhra Pradesh medical.
He has submitted not 1, 3 certificates.
Lordship. Lordship, this is regarding
Page. 190.
193, Lordship. 193. Yeah, his experience was, Lordship. In the subject portion, Lordship. Planning, like linen and laundry services, supply of linen.
And understood, that is one, but
yes,
has he not submitted the others? 195,
Lordship, others, page 195.
197.
195, Lordship, make I see, 195.
195, I'm not. 197, let us see.
197.
Hmm.
Supply of was bedroll items and wooden blankets. But we need lots of setting up of mechanized laundry, Lordship.
Okay. So here the supply, here mechanized laundry is there at page 193.
193, Lordship, he has done only the supply and.
May I clarify, my lord, what my lord?
He has done only the supply of linen and mechanized laundry service. On the supply and mechanized laundry service, the setting up of laundry is not there, Lordship.
Huh?
Setting up of laundry is as per the contract, Lordship.
So it requires that
Laundry
in
is
addition to
set up
that,
by the contract.
so it is, there should have setting up of, should have setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift, while washing minimum of 4 tons of linen per shift for a continuous period of 12 months. Should have setting up a mechanized laundry of 12 of minimum capacity of 4 tons of linen per shift, while washing minimum of linen.
All his experience.
So you mean to say that he has the experience of supply?
He has experience of supply or.
He has experience of mechanized laundry service, but he does not have the experience of setting up of mechanized laundry service.
And it is on good basis, BWT, Lordship. Build, own, operate and transfer. So he has to build a mechanized, Lordship, laundry, then own it, operate it, and then Lordship supply it.
Now, let us see the column in excerpt 12.
But can I make one clarification?
No, wait. Name and address of the organization of experience, address of the laundry dimensions. Yes.
But what the respondent is reading is in certificate annexure 12, they are reading our eligibility conditions, whereas certificate 12 only in respect of the quantum and the work. Lordship would kindly have a look at Annexure 12A.
Yeah.
Identification of single mechanized laundry. But under this clause, I have to give single, Annexure 12A. Then your Lordship would also see 12B. Here I have to give the financial data as regard total receipt, because that has to be related with the receipt for that work. My lord, also look at page Annexure 12C at page 147. There the capacity of the laundry has been prescribed.
Well,
C at page 147. And-
heard that Mr. R. Dubey, the learned counsel appearing on behalf of the petitioner. Ms. RDB, the learned CGC, appears on behalf of the respondent numbers 1 to 5. Mr. So-and-so appears on behalf of the respondent number 6. 6, who submits that he would be filing the power in a day or two. However, he has been telephonically instructed to appear in the instant proceedings. The petitioner herein is aggrieved by the action on the part of the respondent authorities in holding the petitioner's bid to be technically non-responsive, primarily for two reasons. That is, number one, the certificate which is required, the banking certificate, reference certificate which is required to be submitted by the petitioner, though submitted, was not certified by a chartered accountant with the stamp, signature, and membership number. Number two, the petitioner did not have the technical experience of the competence of setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift, while washing minimum of 4 tons of linen per shift for a continuous period of 12 months in the qualifying period, that is current year and 3 previous financial years. This court have heard Ms. R. Devi, the learned counsel, appearing on behalf of the respondent numbers 1 to 5, who submitted that an affidavit in opposition have also been filed. You have filed a reply? Oh, I have filed an affidavit in opposition. It is further submitted by Ms. R. Devi that during the period that although submitted that though pursuant to the completion of the technical completion of the evaluation of the technical bids, the financial bids have been opened. However, no work order has yet been issued. Mr. R. Dubey, the learned counsel appearing on behalf of the petitioner, insisted that there should be an interim order. It is in that regard, this court considered as to whether a case has been made out by the petitioner for grant of an interim order. Mr. R. Dubey, the learned counsel appearing on behalf of the petitioner, submitted that clause 1.3 of part 1 of the notice inviting tender, which is with the heading of system of tendering, stipulates the financial criterion. Referring to subclause capital A, the learned counsel appearing on behalf of the petitioner submitted that there is a requirement of submission of the audited balance sheets duly certified by the charter accountant, oblique certificate from the charter accountant duly supported by the audited balance sheets. The learned counsel submits that there is no quarrel with, there is no dispute that the petitioner had duly submitted the audited balance sheets duly certified by the charter accountant. Referring to clause capital B, the learned counsel submitted that the liquidity aspect have been duly mentioned, which should be valued at 5% of the estimated bid value net of the applicant's commitment for other contracts. In that regard, the learned counsel submitted that to prove the liquidity, there is a requirement of submission of annexure Roman 20, the submission of documents as per the format prescribed in annexure Roman 20 and annexure Roman 21. The learned counsel appearing on behalf of the petitioner submitted that taking into account that the petitioner did not have the 5% of the estimated bid value as the liquidity during the financial year 2025-26, inasmuch as the petitioner's liquidity was only rupees 7 crores 15 lakhs 89,187, which should have been otherwise 9 crores 9.11 crores. The petitioner had submitted a banking reference in the form of a bank certificate in the format provided in Annexure 20, wherein the ICICI Bank certified that the said bank was willing to provide overdraft of the credit facility to the extent of 9.2 crores to meet the petitioner's working capital requirement for executing the said work. The Land Council submitted that a perusal of Annexure 20, the format of Annexure 20, would make it clear that there is no necessity of the certificate, that the said document needs to be certified by the chartered accountant. Inasmuch as the said certificate has to be only issued by the bank, by the senior bank manager of the concerned bank, along with the address, which was so done, which was duly done so, as would be categorically seen at page 214 of the writ petition. The Land Council, referring to the grounds on which the petitioner's bid has been rejected, submitted that the insistence on a certificate that the banking reference should be certified by the chartered accountant on the basis of the second paragraph of clause 1.3 capital B is misplaced in as much as it is the audited balance sheet which has to be certified by the chartered accountant. And in the circumstance, the audited balance sheet contains liquid assets, lines of credit, and other financial means which would meet 5% of the estimated bid value. There is no requirement for the issuance of a certificate in terms with Annexure Roman 20. The learned counsel therefore submitted that it is under such circumstances the words have been used as and/or between the two documents, namely the audited balance sheet and banking reference. The learned counsel further submitted that as regards the second reason, the same is completely misplaced in as much as the requirement of inasmuch as the petitioner duly submitted the required documents in terms with Annexure Roman 12, 12A, 12B, and 12C, which contained different and separate aspects, which would categorically show which are different and separate aspects dealing with the technical experience, that is setting up a mechanized laundry of minimum capacity of 4 tons of linen per shift, while washing minimum 4 tons of linen per shift for a continuous period of 12 months in the qualifying period, that is current year and 3 previous financial years. The learned counsel submitted that insistence upon setting up of the mechanized laundry in Annexure 12 is totally misconceived, in as much as it is in Annexure 12A, the said aspect is conceptualized. He therefore submitted that this is a case wherein the petitioners, the respondent authorities, have not only misread the terms and conditions of the contract of the tender document, but also have for oblique purposes chosen to read in such a manner in order to hold the petitioner technically non-responsive. He therefore submitted that this is a case which would come within the ambit of malice in law and an absolute perverse reading of the terms and conditions of the contract. This would have heard the learned counsels on the aspect, and it is of the opinion that the petitioner has been able to make out a fit prima facie case for interference, in as much as the materials on record and more particularly the documents which have been submitted by the petitioner apparently shows that the reason for holding the petitioner's bid to be technically non-responsive was not in consonance with law. Be that as it may, it is also the opinion of this court that as the respondent number 6 has put in the appearance today, an opportunity has to be granted to the respondent number 6 to bring on record its stand. Mr. G. Rahul, the learned counsel appearing on behalf of the respondent number 6 submits that he would file the reply within 1 week. Mr. R. Dubey, the learned counsel appearing on behalf of the petitioner submits that he would file an affidavit in reply to the affidavit in opposition filed by the respondent numbers 1 to 5. Accordingly, list this matter on 13th of August 2026. The affidavit be filed on, let us have it on 6th of August. The affidavit on behalf of the respondent number 6 be filed on or before 24th of July 2026. Liberty given to the petitioner to file reply thereagainst on or before 4th of August 2026. Insofar as the affidavit in reply to the affidavit filed by the respondent numbers 1 to 5, the said affidavit be filed on or before 31st of July 2026. This court, having taken up the matter, is of the opinion that the petitioner is that any further steps being taken towards the finalization of the tender process would not only result in creation of third-party rights, but would also result in multiplicity of proceedings. Accordingly, this court therefore directs that till the next date, no further steps should be taken by the respondent numbers 1 to 5 to grant the contract to any party. Anything more? I formulated your argument as per what you say. Anyways, give him a copy of the petition.
That has been proved that he is client and the receipt.
Whatever may be.
Yes, I like it.
Give him a copy.
But you will see the last order.
Yes. Yes, so it is not the occupation of 128 BNCRPF camp. So these people are not there. Well, how do you take care of their news?
Yes, still, well, it was taken over by the other firm.
Something has to be worked out because these are workers.
But in fact, I've gone for the agreement also, whether we were signing in the two parties. Only the future
That entity has fled away.
yes, that is very good.
But at the end of the day, it was under APOL. APOL was the government of India, Assam undertaking. I would have understood if it was a contractor, it's a different aspect of the matter. But taking into account that these are workers, these has to be, something has to be done.
But well, the affidavit, they have not denied any liability over the British structure.
State's liability is denied because of the fact that that entity wanted to be taking it over. But that entity fled away. So that entity had not only defrauded them, but also the state.
Isn't it? Somebody who had entered into these people may be actually knowing it at that point of time, but the whole matter. So what to do?
Instruction just claim for 1992 in April 2001. And
Something has to be worked out.
then what you can go for.
Your dues is for retrenchment dues or what dues?
In terms of section 25 FF,
Retrenchment.
otherwise I can help this at this stage.
I think the government needs to go for a one-time settlement or something. Come up with something to do. Because if we go into those respects, it will become huge amount. Something to the effect, should the both parties complain. So you transfer the entire unit with all the money for rupees 1 lakh. The entire transfer was made in 1 lakh. As of date also, you are now giving it to the CRPF. Because there is nobody else residing. But tomorrow, if you give it to some other, at that point of time, nobody was coming to 2001, people were not coming in SAM for investment. Now, if somebody takes it over, private investments are coming. Yes, it's a huge plot of land. So let the government explore with something to the effect as to how deep the petitioners rules can be.
I will have the instruction number. You can tell me that.
Pursuant to the orders passed by this court on 4/5/2026 and 8/6/2026, Mr. D. Gogoi, the learned additional advocate general, apprised this court that the premises of the Assam Politics Limited is under the occupation of 128 BN CRPF camp. The materials on record also suggest that though MS Assam Yarn Suppliers had entered into an agreement on 4/4/2001, thereby the entire infrastructure as well as the assets and liabilities were transferred to Assam Yarn Suppliers, subject to clearing other liability. The said MS Assam Yarn Suppliers is no longer in existence. Be that as it may, the demands of the claims of the petitioners who are the workers are required to be taken note of by the state as Assam Politics Limited was after all a government of Assam undertaking. This court directs the commissioner
and secretary to the government of Assam. Industries Department, na? Commissioner and Secretary. Industries and Commerce Department. To explore avenues as to how the petitioner, how the claims of the petitioners who were the workers would be settled. An update be placed before this court on 9th of September 2026. Structures. And appears on behalf of the petitioner, Ms. So-and-so, who appears on behalf of the PNRD department, submits the petition and becoming practice. Taking into account that the period of the contract, they're taking into account that the challenge to the NIT dated 16/5/2016 no longer survives the instant with petition, therefore stands closed as it has become infructuous.
The principal secretary, respondent one is the principal secretary.
To the principal secretary,
Industries and Commerce Department.
what is this?
Lordship, today is fixed for a report.
What report?
Report from the opposite party.
Supposed to file affidavit as per order dated 2025.
What is the matter about?
Eviction proceeding against petitioner.
What is the case about? Mr. Counsel, what is the case about? No, what are you challenging, madam? What are you challenging?
There's an eviction order against the petitioner.
Where is that?
Or case number 26 of connection 9.
Dilip Kumar Bachchaji.
Lordship.
And what is your case?
My case is
Why you should not be evicted from the government land?
the land belongs to petitioner number one. And the petitioner number two is the president of the village defense party, petitioner number one.
Then,
And
and who are you? Why are you here? Public road. So your land is occupying in 912, original dark number 912. Show me the trace map. Where is 1461? Sixty-one is the path. Huh?
That one details affidavit is required by the tackle officer as per the order that they gave at.
You claim that there was a settlement proceedings going on for dark number 1183. 1183. Now, the settlement officer categorically mentions that 1461 is not apart from dark number 1183. So therefore, you have no business out there.
Lordship, the Revenue Settlement Department, with a view that, as per the survey report, the proposed land is a vacant government land, and the allotment thereof to the petitioner number 1 will be fruitful to check trespass, trespass as well as the encroachment in the land of the government of Assam.
No, you have no right to remain in possession of the person. No, sir.
Lordship, after meeting of the Land Advisory Committee, the
No, then also no right over government lands. What right? No right. You have your application. What has happened to your application? Have you been granted the settlement? Have you been granted the settlement? No. Huh? And what is this Patharpur Kochi party? What is this? What right you have? No rights. You can be granted a settlement and as per 14 acre pound land. Some first. Land. Policy. You don't have a right to.
But earlier on, one affidavit already filed by the circle officer.
Then huh?
Already one affidavit is filed
I've
by
seen
the.
that affidavit. They have also said that.
Yes, Lordship,
that,
para number 9,
1183
Lordship.
is actually a part of that. That cannot be true. You take it this thing. Your allotment will be considered because merely because you are in possession of that. If this is a road out there, that cannot be interfered with others. There's no right, no possession, nothing heavy. The state government will not consider settlement of any government land in Gauhati city or in other town areas under possession of individual or other persons merely on the ground the person concerned in occupation of the such irrespective of the period of such occupation. So, this is not a right to remain out there. Heard Ms. So-and-so, the lay council appearing on behalf of the petitioner. Mr. So-and-so appears on behalf, so-and-so appears for respondent number 1, and so-and-so appears for respondent number 2 and 3. Mr. A.K. Sharma appears on behalf of the respondent number 4 to 8. The present petition has been filed by the petitioner challenging the notice dated, notice of eviction dated DIS 47/2016-17/5084 dated no date, which was received by the petitioner number 2 on 14/9/2016 in connection with eviction case number 4/16-17. It is the specific case of the petitioner that the petitioner that the recommendations have been already made for allotment of 1 kata 1 lecture of land from government dag number 1183 of village Moidamgaon, Muza, Beltola, in the name of the petitioner number 1. And as such, the notice for eviction ought not to have been issued against the petitioner number 2. This court duly takes note of that the notice for eviction is in respect to an area at measuring 2.68 R covered by the government dag number 1461 situated at number 2 Moidamgaon under Beltola Moja. It is the specific case of the petitioner that dag number 1461 is a part of dag number 1183, which was to be settled in favor of the petitioner. This court have duly taken note of the affidavit which have been filed by the respondent number 3, wherein it is categorically mentioned that out of dag number 1183, a new dag being dag number 1719 have been created. Insofar as dag number 1461, the same have been created from old dag number 912. And today, during the course of the hearing, Mr. So-and-so, appearing on behalf of the respondent number 2 and 3, have placed before this court the trace map issued by the respondent number 3, wherein it is seen that dag number 1461 of number 2 Moidam, number 2 Moidam na? What is the name? Moidam. Moidamgaon. Within Beltola Moja. Is different from dag number 1719, which have been created from old dag number 1183. So this court further takes note of the affidavit in opposition filed by the respondent numbers 4 to 8, who have categorically mentioned in the affidavit that they are the absolute owners of various lands covered by dag number 912, 913, 916, old, oblique 1459, 1460, 1462, 1464, 1473 new. at Moidamgaon under Beltola Moza. And here you say contrary to what they say. Why? Why? Because 1183 is a different plot of land. Anyways, everyone. I've also filed the affidavit stating in the alia that dark number 1461 is a road linking the houses of the petitioner, and on account of the unauthorized occupation of the petitioner, linking the houses of various respondents, private respondents. And the petitioner have been illegally in the occupation of the said road. This court have duly taken note of, heard the learned counsels, and have perused the materials on record, including the trace map, which is kept on record and marked with the letter X. The claim of the petitioner for settlement is in respect to a plot of land at measuring 1 katha 10 lechas, covered by dark number 1183. As would be apparent from the various communications issued by the Land Advisory Committee as well as by the Deputy Commissioner. However, from the materials on record, it is seen that dark number 1181 have been subsequently renumbered in the recent settlement operation as dark number 17919. On the other hand, dark number 1461, on the basis in respect to which the notice have been issued, is not a part of the old dark number 1183. In addition to that, this court also finds relevant to take note of that although proposals were submitted as far back as in the year 2015 for granting allotment of land to the petitioner number 1 in favor of the petitioner number 1, but till date, there has been no materials placed before this court that such land have been settled in favor of the petitioner number 1. At this stage, this court finds it relevant to take note of clause 14.43 of the land policy of Assam Land Policy 2019, which categorically mandates that there is no right upon a person, upon an encroacher, to be settled with the land even merely on the ground that the person concerned is in occupation of the land of such land, irrespective of the period of such occupation or encroachment. Under such circumstances, this court does not find that the petitioner has been able to establish any conceivable right to challenge the eviction notice dated impugned in the instant proceedings. This court also takes due note of that in view of the judgment of the division bench of this court in the case of Salakuddin versus State of Assam reported in so and so, a person has a person in occupation of government land has a right to show that the person has a bona fide claim over the said land. Bona fide right of, what is that term you? The bona fide has bona fide claim of right over the land in question. Under such circumstances, this court therefore disposes of the incident with petition with the following observations and directions. Number one, the said notice which has been impugned in the instant proceeding shall be considered to be a notice issued to the petitioner in terms with Rule 18(2) of the settlement rules. Number two, the petitioner is granted 15 days time from today to submit its reply showing that the petitioner has a bona fide claim of right involved over the land under its occupation. Depending upon such decisions so taken by the respondent number 3, who is the circle officer of the dispute revenue circle, further steps may be taken in accordance with law. I gave you something. If your senior was there, I would know. Interim order stamp. None appears for the petitioner on call. This is on the second time that it is seen that on various occasions the petitioner have not chosen to appear. It therefore appears that the petitioner have lost interest in the instant proceedings for which the petition stands dismissed for non-prosecution. Interim orders, if any, stand vacated.
I appear for the ONGC, my affidavit is ready, but I have not been able to get in touch with the counsel for the petitioner. I attempted to file the affidavit today, but we could not get serve a copy of one.
What decision they are challenging?
They're challenging a decision of the Central Information Commission,
Huh?
Central Information Commission.
Commission is challenging.
Yes, the petitioner had basically filed an application, RTI application, seeking certain information dating back to the year 1995. The application, my lords, will find that page 13.
And appears on behalf of the petitioner on call. You are appearing?
Yes, my lords, I
Or
have
respond number?
3 and 4. For 3 and 4.
Correspondent number 3 and 4. This is an application filed challenging the order dated 25/7/2016 by the Central Information Commission in Delhi.
Matter will be adjourned to them. My senior is left up due to some health issue.
No, it's okay. They don't have how to and they give it. He is not competent to address the grievance of the appellant regarding his employment. No, it can't be done. But you are challenging this order. Directing the respondent to furnish the RTI information dated so and so. They don't have the WT message what to do.
And in fact, my lord, the information that has been sought, my lords, is of the year to 1995.
Now they have now given the period also.
They have given the period, my lords. It's page 13 is the application, my lords.
Person must have also retired by now.
In fact, the requirement or the mandate of the 2005 RTI Act also had not come by then. This information is of 1995. They were, in fact, the CIC had also directed them to inspect the records, my lord, official records. That was also, that opportunity was also afforded to them.
But you have given number 3.
Yes, my lord. Whatever we could find, we've furnished, my lord.
Now you could not give number 1 and 2, but you must have given 3.
Yes, my lord.
Huh?
Yes, my lord.
So he had only no problem. He didn't get the number 1 and 2. No. As regards, he's asking for a WT message.
Yes, WT message.
Copy of the reply letter of the said from the director of alia in the said year. You don't have the copy of the reply.
And
You
now,
cannot force them. Or Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so appears for the respondent number 3 and 4. The present petition has been filed by the petitioner challenging the order dated 25/7/2016 passed by the Central Information Commission, New Delhi, and further also seeking direction for providing information to the petitioner. What was mentioned as regards the information sought for by the communication dated by the RTI application dated 22/5/2008. So, the learned counsel appearing on behalf of the respondent number 3 and 4 submitted that insofar as the information which are pertaining to at serial number 1 and 2 of the application dated 22/5/2008, they don't have records of such information. As regards the information at serial number 3 of the application dated 22/5/2008, the same have been duly provided. You have provided that, no?
yes,
This aspect is also seen from the impugned order dated 25/7/2017-16. Taking into account that the said information is not available from us. This court is not in the position now to direct the respondent number 3 and 4 to produce or provide the information which have been sought for at serial number 1 and 2 of the application dated 22/5/2008, and also do not find any error, any illegality in the impugned order dated 25/7/2016 for which the petition stands dismissed.
Thank you. Let me
The respondent was asked to, my lord, that place the instruction on the last occasion, my lord.
What?
My lord. With respect of annexer.
What do you want?
So the respondent number 8, my lord, the petitioner has submitted some representation before the authority, claiming that, my lord, the respondent number 8 is not an Indian citizen.
Or Mr. So and so, the learned
My lord,
counsel.
I have submission. I am for respondent number 8.
So when I'm dismissing his petition, what do you have to submit? Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Mr. Union of India. Mr. S.S. Roy appears on behalf of the respondent number 1. Home, you.
942, 24 and 6. No, 24 and 6.
2, 4, and 6. And whoever it is, give your names. And Mr. M.U. Mahmood appears for respondent number 8. The present petition has been filed by the petitioner, being aggrieved at the inaction on the part of the respondent's authorities in not taking steps for carrying out an inquiry as to whether the respondent number 8 is an Indian national or not. This court duly takes note of that pursuant to the representations were submitted by the petitioner, an inquiry was conducted by the Superintendent of Police, Dorong Moldoi, and by the report dated, who are you? You.
Okay, I'm standing.
Does the Superintendent of Police Border doesn't have money or doesn't have a proper page that he doesn't have a date out here, his document? Huh? No money? Huh? You don't have money. What is the date of this document?
7 December 2015.
Where is it? Why you are giving this half-cut page?
Sorry, not.
Pursuant thereto, the Superintendent of Police, Dorong Moldoi, had carried out an inquiry and submitted a report to the Deputy Commissioner, Dorong Moldoi, on 7th of December 2015, that upon inquiry being carried out, it was found that the respondent number 8 is an Indian national and is the son of late Eyakud, Eyakud, Ali Pusto. It is also mentioned that during inquiry, the respondent number 8 was examined, and during his examination, he had produced some documents, voters list of the year 1966, 89, 93, 97, 2005, 2009, 2010, and 2013 in support of his Indian nationality. Taking into account the said inquiry report is kept on record and marked with the letter X. Taking into account the above, nothing further remains in the instant proceedings for which the petition stands dismissed. Yes, what is this?
My lord, petitioner husband, my lord, died, my lord, during the custody of the state, my lord. And on last occasion, my lord, 3/6/2026, my lord, they
We require some custodial debt. Custodial debt lordship will be go to division bench 2.
Ranju Begum.
What is he asking for?
Custody,
Why will it go to the division bench too?
custody in that lordship.
So what?
Inquiry.
You are asking for an inquiry.
An inquiry, independent inquiry, my lord. And my lord, petitioner is undergoing, my lord, trial period, my lord.
You go for division bench too?
Yes,
Why do you think?
yes.
Then why all this time they have been filing affidavit of guilt? What do you want?
My lord, an independent inquiry, my lord.
CBI?
CBI or any, my lord, judicial inquiry, my lord. Because, my lord, the case against the petitioner's husband, my lord, there is involvement of 10 crore, more than 10 crore, my lord. And my lord, he have repeatedly, my lord, complaining about his chest pain. And my lord, there are other ailments, my lord. Due to negligence of the jail authority, my lord, petitioner husband expired, my lord.
Jail authority?
Yes, my lord.
Then police custody.
No,
Jail is police. Jail is police. Are you, as the government council saying that the jail and jail authorities and police are same? A government council is saying that the jail authorities and police authorities are same. Then? Or has the state of Assam made the jail authorities and police authorities same? Then how are you saying this to be a case of police custodial death? He died in jail.
Yes, my lord.
Then police action. Custodial death matter.
Due to negligence of the jail authority, my lord.
The present petition has been filed seeking for an independent and impartial inquiry on account of the death of the husband of the petitioner who expired while remaining incarcerated in the Gauhati. What is it?
Central jail, my lord. Yes.
Gauhati jail?
Yes, ma'am.
In the central jail at Gauhati. The question arises as to whether the instant matter can be treated as a custodial death matter or any other matter. Inasmuch as if it is a case coming within the ambit of a custodial death matter, the matter has to be referred to, has to be dealt with by the division bench number 1. Here it is 1. By that. No. The division bench 2. The registry shall duly inquire and thereupon place the matter before the appropriate court. Yes, what is your case?
Next legal action.
The petitioner is a,
Huh?
petitioner is a lessee under the respondents, my lord. And in the year 2021, my lord, the respondents, my lord, floated a tender. The petitioner participated in the tender, my lord, and he was chosen as the sole bidder, and an agreement was also entered into. However, my lord, there was a condition by the petitioner that the escalated rate that is non-negotiable. Thereafter, my lord, again re-auction was done in respect to the shop that was earlier settled with him. So
Who settled?
the respondents,
Who is responding?
respondent, my lord, we, my lord, will kindly come to page 32. Page 32. This was for
So
an
it's a lease agreement.
yes. Lease
Now, what has
agreement,
happened to the lease? What is the period of the lease?
lease agreement, my lord, the latest of the lease agreement is of 2018.
And then,
Thereafter, it was not extended.
what is the period of the lease?
11 months, my lord.
But it may extend to 5 years.
Shall
But-
remain in force for a period of 11 months from the date of commencement mentioned. The lessee reserves the right to renew the same for further period of 11 months.
Yes.
Then,
Yes, period of allotment and license.
then what happens? Now what do you want?
My lord, may kindly come to page 31. Page 31, my lord, will kindly see at serial number 10, my lord. This shop number which I am a lessee is shop number 15. Serial number 10, shop number 15. The amount which I was paying at the year 2019 was 3,500 as a rebate. Thereafter, my lord, will kindly come to page 32. They floated a tender, my lord, in 2021. So although date is not there, but the auction date with effect from 1st March 2022, and my lord, will kindly come to serial number N. Page 32, serial number N. Shop number is 15. Print area is
Serial
12.
number?
Page 32.
Ah,
Serial number N. Shop number 15. Print area of the shop 12.48. And on the right hand side, my lord, will
shop number?
15.
15.
Yes. And my lord, print area, my lord, will see 12.48. And on the right hand side, my lord, military store.
No, go up. The book and stationery shop.
Yes.
15,000. Yours was book and stationery, na?
Yes. But however, they changed the name, my lord. On the right hand side, my lord, will kindly see it
Okay,
is.
anyways, what do you want now? Yes, tender issued then.
Yes, I participated.
Then,
And the rate was, my lord, in the initial tender was 15,000, which I challenged, said that no, 15,000 is an escalated price. Thereafter, in the affidavit, they have also stated they rolled back. They have rolled back the escalated price. 15,000, it comes down to now 3,850. So as regards that escalated price, my lord, the grievance has been settled. However, my lord, during the pendency of this writ petition, my lord, what they have done is that, my lord, they regularly they have been issuing, my lord, this tender, 1 year tender after the 1 year period is over. I was protected by the order of this honorable court of 9/6/2022 that it will be subject to settlement, will be subject to outcome of the writ petition. However, I may participate in the process. But my lord, in the meantime, if I may hand over this.
now what happened?
My lord, will kindly come to page 3 first, my lord. Page 3. In the 2025, my lord, they again issue this tender for 2025, and kindly see the serial number F, shop number 15, electronic shop oblique mobile shop, Flint area 10.334 and
But yours was 12 point something.
12.48.
You made
And
that.
and G is shop number 16, cloth oblique dry clean shop 11.35. Why I'm pointing out this shop number 16 also, my lord? Because, my lord, Initially, I was under the
Now,
impression,
what do you want now?
my lord, I am ready to participate. I am ready to participate in a tender process. However, my nature of business has been changed, my lord. My nature of business was military store. Now they have changed it to, my lord, this dry clean cloth oblique dry clean shop. Although,
No, it is different. It's a different shop.
no, my lord.
Yes. You were given this earlier, it was, these are different shops. These shops are different. Your shop was earlier,
Shop number 15.
no, earlier your shop was shop number 15.
Yes.
For running a shop. Shop number 15 is electronic mobile shop now.
Yes. However, my lord, this electronic, I was also, the petitioner was also on the impression that this shop number 15 is electronic and mobile shop. My lord, may kindly come to this letter which I have given just now, my lord. 11 July 2025.
Later on, shop number 15 became book and stationery.
Now,
Then it became, shop number 15 became military store.
yes.
Now what do you want?
Now, my lord, what has happened,
Now
my lord?
they have given the shop number 15 to be electronic mobile shop.
Yes. However, my lord, this is also not the shop number 15 which I am occupying as of now. It is this shop number 16 because
Now what do you want? Did you participate in the tender
no.
earlier?
Yes, I have participated.
Did you get it?
Yes.
Now what do you want?
Lord,
Your repetition has become infructuous.
yes. Yes, my lord. But to that extent, my lord, I am ready to,
How on earth, in respect to a 2022 petition, I can take into account a tender of 2025, that too in the year 2026?
Because-
And where do you come to?
My lord, pair is there, my lord.
yeah,
No, absolutely no. You
There is no-
participated pursuant to the said tender notice? You
Yes.
got it? We are over. I have heard Mr. NBP Sinha, the learned counsel appearing on behalf of the petitioner, and Mr. A.K. Doctor, the learned counsel appearing on behalf of the respondents. Mr. NBP Sinha, the learned counsel appearing on behalf of the petitioner, submits that the instant reputation has become infructuous. Accordingly, the reputation stands closed. It is observed that the closure of the instant reputation shall not preclude the petitioner to participate in fresh tenders which have been issued for the shop inputs.
my lord, as regards only the nature of business, my lord.
Absolutely.
Because otherwise, my lord, it will be difficult for me to
You
participate.
do whatever business you want to do, you have it outside a military gun and inside a dry cleaning, do whatever you feel. This. Yes, what is this?
My lord, this matter is there for compensation, my lord, that in this regard, my lord, already, my lord, the
What
authority.
comfort? Alleging wrongful disbursement or in favor of the respondent for requisition of land, the instant which has been containing the requisitor are also entitled to receive compensation. Why should we interfere?
My lord, what happened, my lord? The
No, nothing. There.
authority
It
has
is a case. This is acquisition for what?
for the four lane, my lord. Extension of the four lane, my lord.
Under what provision?
National Highway Act, my lord.
384. This court is not going to hear on this.
My lord, actually, what happened last occasion, my lord, what happened?
Last occasion, people, you see, the other judges are very kind judges. They
No, not the-
notice out here.
No, no, that is
On
not.
the first day, this petition should have been not arbitration. It is a question of entitlement.
No, it's not entitlement. That is not. I am entitled. It is admitted fact, my lord.
Then
What happened, my lord? There is only on the basis of that affidavit submitted by the respondent number 5, and the amount has been deposited to his account. Whereas, my lord, we are similarly entitled to get the share of the compensation.
understood. So therefore, what should we do? Go there.
No, actually, what happened in the similar case, another case in the Gauhati, my lord, their lordship observed
that the direction was made to the respondent authority to take the initiative. In the respondent authority, what happened, my lord, in my case, my lord, they have issued a notice to the private respondent that said that you have to deposit our share to in our account. In spite of that, my lord, the authority will take the action against the respondent number 5. But now by affidavit, the respondent authority say only on the basis of the affidavit submitted by the respondent number 5, saying that the amount should be deposited to his account. After receiving the amount, he will distribute the all key between the all shareholder, entitled shareholder. And but after getting the money, he did not do so. Prior to affidavit, my lord, he has put his signature in an agreement. He will sue. He will sue them. You have a way with him. He will sue. No, I am coming to that point, my lord. But again, thereafter, my lordship asked to this respondent that my lordship's order is available is there. Without the bond and without the NOC from the petitioner, my lord, they have deposited the entire amount to you. My prayer before your lordship is that the direction may be made to the respondent authority to take the appropriate action, the appropriate steps to recover that amount by them. Why? Because my lord, illegally on the basis of the without taking the.
What is the interim order part?
Interim order part that there is a two land, my lord. The one the compensation amount for the one.
What is the interim order part?
Lordship, another amount should not be released. There's a two land, my lord.
So 1676.
Yes, my lord.
There is a dispute.
This is the dispute.
Who there? You will file 384.
No, no.
Fine. And then out there claim that amount. It will be a decree of the court. See, it will be a decree of the court. Get it executed from them. If they take somebody else takes the money, he will be a party there, no? Get it executed from him. That is the order you can get.
Actually, what happened in the similar case, my lord, that is also the
There is no
lordship's order.
similar things. If similar cases, some judges have come, some judges have given a judgment to the effect.
This is your lordship's order.
What did I say?
The lordship's order in that case, my lordship said to take initiative and accordingly when a 50 lakhs. That's similar case, my lord. 50 lakhs that is deposited from somebody else. And now, my lord, as per lordship direction, observation, the authority has seized his bank account and police case has been filed. Police case has been filed. FIR has been filed. And thereafter, after that order, my lord, this is the order of another.
No. After this, what has happened?
This order.
Final order is what?
This order, my lord, 50 lakhs. That is. This is Sri Probin order, respondent number 8, hearing until further order, and also the intimate the ADC regarding the balance amount in the said bank account.
No. But final disposal order. Don't come up
This
with
is
this
still
interim
pending,
order.
my lord. This is still pending.
No, it can't be pending. There is one matter which was there. I finished it off. This matter where Mr. D Das was appearing
yes,
on
sir.
one side
Yes,
and the other side was appeared by some Praveen Mohanto or something. Isn't it? Yes, I remember. Now this is the Jurhat case. I remember. So no, I have not passed that order. This order is not going to be. I am not bound by this order. Now question is 223. You see, why, as regards 1676, if you have a claim, why should this court entertain this type of disputes? No, you're not going to get it. You go there. You see, I make it very clear. The authority, the competent authority,
Yes.
under 3H3 has no jurisdiction if there is a dispute to disperse them. And as you have raised, if you raise a dispute before that authority, the same amount, you go there, the authority will pass an order. It is a district judge who is going to pass that order. And after that, it will be executed. If he has taken the money, he will pay. with interest.
Yes, madam, in this affidavit, by affidavit, madam, authority admitted that matter I am entitled. And it is on the basis, authority has, by the affidavit, madam, affidavit has been filed. The color has been filed, the affidavit revenue, the ADCA revenue said, yes, the petitioner is entitled to get the
And
money.
why did the Kala pay the money to him?
Yes, I don't agree with that.
Why? Why have you did? Once you agree that the petitioner is entitled, why did you make the payment?
Because
The affidavit is that he will divide the amount,
Who?
the respondent of 5 lots.
He.
Yes, that's.
He said that he will divide. Who is he? How are they related?
this affidavit, only on the basis of the
Who
affidavit,
are you? Who him?
we are all the similar footage, my lord, we are the not landlord, my lord, we are the occupier of the land. This amount is for Zirat and other included, my lord.
So then why did you give it to him? I think it should be taken from the salary of this person concerned. I think we should make him a party. Who is that officer? We make him a party with. As to why it should not be taken from him. That person who has filed the affidavit.
This is ADC, my lord.
What is his name? Let us see.
His name is,
What is his name?
my lord, there, my lord, in affidavit file.
Where?
কি নাম দিবি?
I think this land acquisition has become a case of corruption. Who is this person? Additional Deputy
Ma-
Commissioner Dorong.
His name is Anurag Phukon, my lord.
What does he say? After verifying all the documents, responding on the basis submitted by the Iman and another amount of the Iman as 3G prepared by so and so and is not paid up for Iman. So and so. As informed by the circular officer for the affidavit submitted by the respondent number 5 and mutual understanding. So and so in retaining intelligence of the circular officer so and so and so and so and so. What is your name?
My name is Ayazuddin Ahmed and Ayazuddin Ahmed.
Majibullah.
Huh?
Ayazuddin Ahmed and Majibullah Ali.
Citizen.
Majibullah Ali has no business out there. Shirazul Haq,
Shirazul Haq is the respondent number 5, my lord.
Aizuddin Ahmed, Abdul Ali and Sirajul Haq. There is an agreement.
Actually, Majid Sheikh is the name. He is there, my lord. He is the representative, my lord. He has the petition on board. Legal there.
What is the total amount?
Total amount
5
in
lakhs.
one is 5,70,000, another is 46,000. So 5,70,000 in the has already been disbursed and 46 lakhs is pending due to the stay of the
45,000 is pending.
pending
5 lakhs has been disbursed.
disbursed.
But let Anurag Phukon give it from his pockets.
No, he has filed the affidavit, Lord.
He is the additional DC. He's the competent authority, Kala. Let him pay the money from his pocket.
Only basis of
We
that.
direct we have to attach it, ask him to make the payment to the court, and from there we will distribute it. Less the amount which has he said. And let him recover it from him. Because the government cannot be there. And if these officers have no idea, that for them the law, if they walk on this road, by this door, the law comes from the other door. If that is the thing of these officers, then I think they are not fit to be officers. I think we should have call this officer and hear from him what is his conception of land acquisition. List this matter again tomorrow. Friday at 10:30 AM. Personal appearance of Buddha.
It is there, Lord. He has transferred that to the donor.
What?
It is not there. The person to download.
Whoever it is, these officers should not be anywhere nearby to, they are not even fit to even become in a this Mondal, they're not fit. They don't know the law. Or I think there must have been some dishonesty on the part of this officer, otherwise they would have never done that. Because 3H3 makes it very clear that when there is no dispute, you pay. Then why he believed upon an understanding which the circle officer reported that he is going to pay to all these people? Who was the officer who released the amount?
This one, or what?
We make him a party by in-person. This court have duly taken note of that there has been a complete dereliction of the duties by the additional district commissioner Dorong Mongoldoy, namely by an officer namely Anurag Phukon, who is the additional district commissioner Dorong Mongoldoy, in discharging his duties as a competent authority in terms with section 3H 3 bracket 3 of the National Highways Act 1956. This court observes so on account of the fact that when there is a dispute, the officer concerned, the officer who is the competent authority, could not have decided the entitlement and rather ought to have referred the matter to the court in terms with section 3H4. There is no materials on record to show on what basis that the respondent number, that the said officer, namely Sri Anurag Phukon, had disbursed the entire amount of rupees 5 lakhs.
5 lakh 7,022.
7,022 in favor of the respondent number 5. Although it is well accepted in the pleadings by the competent authority for land acquisition that the petitioners along with the respondent number 5 had equal shares in respect to the said amount. Under such circumstances, as it appears to be a personal dereliction of duty, a dereliction of duty by the authority, by the officer concerned, this court would not like to would not like to reprimand and impose and pass appropriate directions against the officer without giving him an opportunity of hearing. In that view of the matter, this court impledes Sri Anurag Phukon, Additional District Commissioner Dorong Mongoldoy, having his office in the office of the District Commissioner Dorong Mongoldoy, as the respondent number 6 to the instant petition. The said officer, having filed the affidavit before this court on 12th of March 2026, is in no of the present proceedings. Is in no, is not only in no of the present proceedings, but also the contents of the proceedings. The said officer is directed to show cause as to why the said amount which have been disbursed to the petitioner should not be recovered from his salary, should not be recovered from him. Now, as to why appropriate directions should not be passed against him for recovery of the amount which prima facie have been illegally disbursed to the respondent number 5. The petitioner is directed to counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court. The petitioner is the registry is further directed to forthwith transmit a copy of this order to Sri Anurag Phukon, the respondent, newly impleaded respondent number 6. In addition to that, a copy of this order be also furnished to Mr. D. Nath, the learned senior government advocate, so that he may duly intimate the said officer the affidavit be filed by the respondent number 6 on or before 18th of August 2026. List the matter on 28th of August 2026.
My pleasure, Lordship. My lord, in this matter, the petitioner is aggrieved by an order, my lord, the decree of divorce, my lord, passed in his favor, my lord. Lord, that order is without jurisdiction, my lord. As my lord, here, my lord, respondent number 4 has passed a decree of divorce, my lord, in favor of the respondent number 3, my lord. Petitioner being the husband, my lord. My lord, on earlier occasion, the petitioner has preferred an writ petition before this honorable court, my lord. Wherever, my lord, it has been stated that the Qazi has no jurisdiction of passing any order of divorce, my lord. Despite there being any such order, my lord, the decree of divorce has been passed, my lord.
Yes, what is your instructions, respondents?
Instruction logic. No,
Who is appearing for respondent accepted notice?
I put
Revenue you are appearing. Now, does he have the jurisdiction authority? At that point of time in 2023, Tula Talak registration.
Yes, Alex. Well, they had to file a notification, Alex. The respondent had to file an affidavit also, Alex.
And what about the service upon the respondent number 4?
Well, have been newly appeared. If service has not been done, well, then I'll do the service.
Service is awaited.
Well, I have recently appeared, my lords, in the last occasion. So if it is not done,
On behalf of the petitioner, we're filing here, issue notice here. The records do not show that the service is complete as regards the respondent number 4. Counsel appearing on behalf of the petitioner is directed to take fresh steps upon the respondent number 4 by way of by way of speed post within 7 days. List this matter again on 16th of September 2026. In the meantime, the respondent numbers 1, 2, and 3 shall bring on record their stand by filing the affidavits.
extra copy.
I'll extra copy also.
Extra copies of the petition also be provided to the respective councils by tomorrow.
I'm so blessed.
May it please your worship. Your worship, may the matter be possible for the day. Because my line is out of station due to some personal issues.
Yes, GMC?
We already submitted one instruction on 22/4/2020.
What is the matter about?
Regarding my lord, that demolition of my lord, some portion of that building. But they are encroaching the government land. So we saw that the PWD drain is there. That was my lord 4 feet. Something like that.
Why haven't you filed your affidavit?
So, my
In
lord,
spite of there being an interim order. Interim order has been there for 2 years. So we do one thing, make it absolute.
already
Don't
my
worry.
lord, that
We don't have any idea of, you don't. You are
Lord,
not
to my
inclined
kindly go to that instruction. It was already been placed before the summer.
Huh?
The instruction already been placed on.
Are you not required to file your affidavit?
Let me file.
Two respondents are allowed 2 weeks time to file their response to the petition, and the petitioner may take 2 weeks. That was done in 2025. Time was again taken. Mr. J. Hendick obtains for filing the affidavit in opposition in 2024. Every year the matter would come up and you are taking time after another.
No, we already been communicated.
It is seen from the records that on 1/3/2024, notice was issued. And more than 2.5 years have already passed by, but the respondents have not yet to file their affidavit. It is seen that every year when the matter is listed, the counsel for the petitioner respondents have leisurely taken time for filing their response, but till date, no affidavit has been filed. Considering the above, today also Mr. J. Hendrick, the learned counsel appearing on behalf of the respondents, seeks for time for filing the affidavit in opposition. A final opportunity is granted to the respondents to bring on record their stand by filing the affidavit. List this matter on 6th of January 2027. Interim order passed earlier shall continue till the disposal of the petition.
I love it.
Yes, Mr. Day.
This is regarding under compensation for acquisition of land under Assam Mala scheme. Under my land, 6 kathas, 2 chatas were acquired. No procedure was followed. Man, I was suddenly asked to take compensation of rupees 2 lakh something. It's very less matter, no negotiation, nothing. No agreement, no agreement. Then Assam Mala cannot apply.
Can Assam and Mala apply without an agreement?
Oh,
You have not taken the 2 lakhs?
no. So far, I was not taking it, but present, I have no.
You don't want the money.
I need some time, doctor.
We take it out from the deed requisition.
April,
No, you have not filed your affidavit. 2 years. 2 years. Not to carry out any work on the land. Because you have not carried out anything. Grants a period of 4 weeks as a last opportunity. What is it?
Sorry.
I'll pass an interim order. Not to carry out any action on the anything on that land. This acquisition is made under what? Where is the notice?
And the notice is at page 19, man.
That it is hereby notified to the Imam of the land that the district level and purchase committee have decided to acquire the quantum of land as shown below against the Moses earmarked as under as a following revenue circle through direct purchase by way of a negotiated settlement for updation of so and so. So as of now, nothing has been done.
And then when you can see on page 29.
He served upon to inform you that you have been found to be a beneficiary in the Akoma and an award of rupees has been passed on the 23 and 30 of the 2013 Act. What? Two 2013 Act, if you have done it, you must have been, it cannot be under Samala. It has to be on the basis of the earlier one. Well, 2013, which means that it has to be preceded by a notice under section 11 and a declaration under section 19, which you have not done. So we set aside this. Heard Mr. K.K. Day, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers. Revenue. Mr. Al Gopudari appears for the respondent number 1. Who appears for the district level purchase committee? So and so appears for respondent number 2, 3. And what about 2, 3, 4? And so appears for respondent number 5. The petitioner herein have approached the spot upon receiving a notice that an award has been passed in respect to their land under section 23 and 24, the 30 of the Act of the Right to Fair under of the 2013 Act. And it is the case of the petitioner that such acquisition has not been preceded by any notifications or declarations as are required under section 11 and 19 of the Act of 2013. Mr. K.K. Day, the learned counsel appearing on behalf of the petitioner, further submits that even the requirement of steps being taken as per the Assam Mala project requires that there has to be an agreement. And in the instant case, there is no agreement. It therefore appears, the records reveal that notice was issued as far back as on 18/3/2024, and notices were duly received by the respondent authorities. But till date, there has been neither any instructions placed nor any affidavit filed. Neither any affidavit filed nor any instructions placed. It is the opinion of this court that the private lands of a person would be construed to be properties within the meaning of Article 300A of the Constitution, and deprivation of such property can only be resorted to by authority as per the procedure established by law. In the instant case, there appears to be no procedures followed and just and the respondent authorities have have tried to take over the land of the petitioners in complete violation of the provisions of Article 300A of the Constitution. The above is the prima facie opinion. Accordingly, this court is of the opinion that the petitioner's possession, the petitioner's rights as well as possession over the lands in question, over the land of the petitioner would not be impacted, shall continue to remain with the petitioner till the next date. Taking into account that the respondents have taken 2 years for filing the affidavit till they have sought and have further sought for time. List this matter again on 11th of January 2027. In the meantime, a final opportunity is granted to the respondents to bring on record the stand. Till the next date, the petitioner's possession over the lands in question shall not be disturbed by the respondent authorities. Further to that, no further steps be taken unless and until due notices have been issued, the due notifications as well as declarations have been issued as envisaged under law.
The sole respondent, but we didn't file the affidavit reply. So can I be accommodated for 1 week? Your lordship?
Manoj, I'm
And next week
appearing
I'll
for the
file affidavit
respondent.
reply, Your Lord. Sole respondent has already filed the affidavit in opposition.
Okay.
So I need 1 week time to file the affidavit reply.
2024 years.
Yes, Your Lordship. Actually, certain documents in the above, certain
How many
documents-
years? I'm getting the interim order.
Your Lordship, only for one. Only for one.
Absolutely no. No interim order.
This is the interim order.
What is the interim order you asked?
We have challenged the order whereby the petitioner's firm was debarred from participating in tender
So?
for 5 years. That was not to be given effect. That must
No, sorry, you have not filed the affidavit. Sorry.
by
You
next
cannot,
week, I'll file,
otherwise-
Your Lordship.
Otherwise, we take up the matter for final disposal tomorrow.
Yes. Next
It's
week.
the matter
next week,
tomorrow at 2 PM for final disposal.
Lordship, can it be next week, Your Lordship?
Grateful.
Tomorrow. If the interim order is clear. Tomorrow.
Friday, Your Lordship. Friday.
Tomorrow.
Day after tomorrow.
Tomorrow. Day after tomorrow, you want, I can have it after 2 weeks also. No interim extension. The counsel appearing on behalf of the petitioner submits that he requires 2 weeks' time for filing his reply.
Interim may be continued.
No.
Lordship,
List this matter again on 10th of August
Lordship,
2026.
then tomorrow.
No, sorry.
What is
You
the interim
missed it.
secured, Your Lordship?
You missed your chance.
I'll somehow file the affidavit.
No. You
Manoj, interim order has been vacated.
and you now, after 2 years, you are taking this time. Don't ask for it. Sorry.
My fault. Your Lordship, that tomorrow.
Okay,
Your
then I can allow you
tomorrow.
cost of 10,000 upon.
Tomorrow without cost, I'll file the affidavit and tomorrow it may be finally disposal. Tomorrow.
List the matter tomorrow at 2 PM for final disposal. Interim order passed earlier shall continue till then.
Grateful, Manoj.
Yes, Mr. Saikya.
Use of unauthorized constructions of the respondent. And we have filed the, affidavit reply yesterday only. And the affidavit was filed by the GMC. We have filed the reply yesterday only. That
You have
has not
filed your
come
reply yesterday.
yesterday.
Mr. Swanfo, the learned counsel appeared. Also Saikya, the learned counsel appeared on behalf of the petitioner submits. The petitioner has filed an affidavit in reply. However, the same is not on record. registry shall bring on record the said affidavit in reply. Yes, any urgency, Mr. Sakia?
Urgency here.
Urgency.
Because we, unauthorized construction, he is again going to build another construction without permission.
Accordingly, is this matter on 11th of August 2026 for final. In opposition side. We are fine. This is on the question of input tax payments. You have not filed a reply?
My lord, that is not necessary, my lord, because I am the purchaser here.
Huh?
I am the purchaser now. The fact of the case is, your lordship, I am the purchaser. I have purchased two old generators from respondent number 3, the CR group, your lordship. And I have paid the tax to the supplier. He is the supplier, my lord, respondent number 4. So, my lord, I have paid the necessary GST and other taxes to the respondent, to the CR group, which is respondent number 4. And they duly accepted that with the index.
Judgment of the.
Yes, my lord, it's a covered case, my lord. I have
Sir, what is the name? Some plastics.
Mercedes.
National Plasto. Plasto. Okay, we do one thing, we can have it tomorrow. Not finish it now. Tomorrow at 2 p.m. Finally. What's the matter about?
The matter relates to allotment of land, lordship. What has happened, lordship?
You have not filed your affidavit? So why you have not filed it? 27/10/2025, you have sought for instruction. And 1 year, 7 months have already gone by. A final opportunity is granted to the respondents, bring on record their stand by filing the affidavit, failing which the instant petition shall be taken up for disposal on the basis of materials already available on record. This the matter on 12th of August 2020.
Obliged.
What is the matter, Mr. Sakia?
Lord, the land was acquired long back, 15 years. Then we approached twice and we put on the High Court. On the first occasion, the High Court directed them that you please prove that the money was paid to them. They failed. Then second time we filed the case and the Honorable High Court ordered page 63.
Yes, who is paying for the government? Why they have not filed the affidavit?
Since no award was passed, no company has paid. So we filed this case, my lord, for to
under section, right to, under, under Registration Act 2013. Because since the award was not passed, they are proceeding lapse under the law. So the Honorable High Court also directed that if the party is agreed, Lordship at page 68 medicine.
Yes, by having to file the affidavit, if you only been communicated, but an instruction not yet received. Which is the department? Or the deputy commissioner metro. Where? Kamrup. Metro. We call the DC. DC, na? Not. The records reveal that notice was issued on 27/11/2024. Service was duly accepted by the government advocates. On 8/5/2025, the government advocates again sought for time on the ground that instructions have not been placed. Today also, Mr. J. Henry, the learned standing junior government advocate, submits that the District Commissioner Kamrup have not placed the instructions. Considering the above, list this matter again on 31st of July 2026 at 10:30 a.m. on which date the District Commissioner Kamrup Metro Gauhati shall be present through the video conferencing link to be provided by Mr. J. Hendick, the learned junior government advocate, and answer as to why, in spite of various instructions being sought for by the government advocates, the instructions have not been provided by the concerned officer. Yeah, but it is prisoners. Transferable.
Government of Assam has recently the minor Manipur government commissioner, Home Manipur Secretariat, but we haven't received any instruction from, any response from the Manipur Manipur.
We'll have this on Friday then. List is back on Friday. As both the state councils duly have the instructions. We have the instruction.
We have written, but they have accepted. These instruction is minor.
In its court.
Okay.
Okay.
Nine 40 your lordship, definitely you're going to find by them, last occasion your lordship. Just 2 weeks time, fine, that's definitely.
Academic file by response number 4.
Yes, that was what we need to file.
You
it.
don't want to file reply.
We will file it, 2 weeks time maybe.
In 39,
Post check, 3940.
Mr. P. K. Sharma, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file an affidavit in reply to the affidavit in opposition filed by response number 4. To list this matter only upon such affidavit in reply 5.
Public.
Yes, any urgent matter? Any urgent matter? Yes, Mr. Mark. What is that?
Not, there is an order in my favor, my lord. That order has been violated by the respondents, my lord. So I file a miscase, my lord. The police atrocities is going on against us, my lord. In spite of this,
Friday?
item 49.
Friday?
Friday. Public.
What is that?
It's a husband was applied on electric vehicles on 2023. So already hearings completed. It was already the
Let's have it on Monday. They file your affidavit. And there's the electrical accident report. What is that? Whose favor?
against the issue. Again, against the decision, the no negligence happened at.
So therefore, he has to go and file suit.
That appeal. No, no, this is specifically engaged by the engaged by the private contractor. CPGF, which is appointed by the APC. So if this agent was appointed by the APC also. So he is the master also.
So then you have to go and ask for the workman compensation.
That's it. As per.
Why you are here?
That's it. As per notification. Already, as per notification.
Let's have it on the Monday.
Monday. Well, I can put it clear, we have to
Yeah.
emergency, it can be listed on Friday.
What is that?
And maybe because my lord, we have land that is allotted in our names, the patra has not given to us. Those similarly persons have been provided. On
Not
Friday.
Friday, Monday? Monday.
Okay.